means out of go out of India, but this cannot have
Where he-
authority held up.
Where he will go for cardiac treatment? Which country? India is the best country for the cardiac. Which country you want to go for the treatment?
They have also said the Canada. But I am, but he's a senior citizen. He's the one of the domicile certificate has been retained, and one of the primary counseling of the for teacher is going to be held last week of August. One or two matters.
I am compelled to mention
Tomorrow.
I am compelled to mention this one also. Urgency is the warrant issued by the communal forum against the principal, but completely natural justice violation.
Principal means?
Principal of the college violate. For non-refund of admission fees of students. But the consumer forum passed an order against the execution proceeding or the arrest warrant issued, neither the parent order nor any proceeding.
Why you not file an application before the forum?
No, the 14
you could have been file an application over there for
that cannot be custody of the
state forum. State forum.
No,
District forum. Why you not went to the state forum?
No, because of this is the district. That's why there is no state forum, my lord. The commission also.
The state commission is not there.
This is not forum. Commission.
State commission is not there.
This is the commission of the state. Here, district redressal commission itself, Kolkata too. My lord, can you see? This is a commission.
District Consumer Dispute Redressal Commission.
Yes, my lord. Kolkata. Well, can you see the order passed by neither the parent order nor communicated. Neither from the complainant nor the commission. Proceeding, the parent order not communicated. Nothing has been done, my lord. The 14 is the date, my lord. Kindly, but tomorrow I have.
Serve the notice.
I shall serve notice. I have 26 ballots also.
Deeply obliged. Me to mention, my lord, today is the last date of interim order. So my lord was kind enough to say within the 10 matters that is not yet. Item number 56. Well, let it be tomorrow under extension.
It is today when interim order is still today. Okay, if the court will not reach, come before rising of the court. Mention, I will.
May I mention one matter, but on to be mentioned for correction, well, the name of the state, I appear for state, but the
See, you persons are appearing, I am passing, and again the matter is coming. I will not correct any order with regard to the name. Only if in the body of the order, if any required, the same persons are not giving the name. You are not mentioning the item.
I have already mentioned, my lord, already.
Yesterday I find this bench of the mentioning list, out of this bench, the matters only for the correction of the name of the advocate, either the petitioner or the respondent.
This matter had on 5th August, my lord.
Again and again, if the matter
Assembly slip in my name, I appear, I have given slip to the officer. Well, kindly correct, my lord, otherwise, my lord, I will give it.
But where is the order?
Assembly slip to the
Who has appeared for the state? Rajan Datta.
I appear.
What is the good name?
I joined the court because I see assignment slip, my lord. I have already understood.
Yes.
Assignment slip, my lord. Can you page 2? Edit to the assignment slip.
This is original.
This is the original, my lord. Well, the assignment is my name, my lord. The previous has the allotted, my lord.
Original.
I take to the side, my lord. Take to the original, please.
My lord, I have the same issue, my lord. I will not. Name that is appearing wrongly on all the correction. Every day I will not allow. My lord, the advocates of the. You mentioned at the time of raising bill. You mentioned in the.
May I please mention a matter, my lord? This is an unlisted matter, my lord. This set of invocation of bank guarantee. Although we have sought dispensation under 26, I am praying for short service, my lord. If my lord may pick it up tomorrow. Most great. Short service.
Serve the notice.
Yes, sir.
Tomorrow within 10 minutes.
But if you not because of that, proceedings, all the functioning of the individual has completely stopped. Lordship, kindly gives me some precedence.
Yes, tomorrow it is fixed.
It is listed new motion listed for tomorrow. If your Lordship kindly keeps it within the first 10 matters, also we'll try.
Where is the list?
But I'll give.
कर दो कल 10 मीटर के अंदर का within 10 कर. Yes.
May I be permitted to mention, my lord?
The mentioning.
My lord, it is related to a matter coming up tomorrow, my lord.
Yes.
My lord, tomorrow, my lord has fixed a batch of matters relating to Manrega contractors. Now, my lord, my matter is also similar, my lord.
Let the matters come. If you see, because one day the matter will not be finished. If it is fine, I will not see.
Urgent matter.
What is the urgency?
Petitioner passed NEET examination.
Huh?
Petitioner passed NEET examination 2026 as a OBC candidate. But now my certificate is not issued.
So what the court will do if the certificate is not issued? What the court will do? Huh?
Going on, madam. Counseling is going on.
So what the court will do? Court will exempt the OBC. Tell me whether the court can exempt the OBC. Tell me if you say yes, court can exempt the OBC, then I will take the matter and I will ask the where is the law? If the court will can exempt the OBC. Huh?
The authority.
Well,
kindly relegate the matter, madam.
Relegate the matter?
The district magistrate, madam. I'm appearing in person.
My lord, my files are here, my lord. If my lord, I have mentioned it prior, my lord.
Let the matter come. We'll see if other matters there. Then I will pass.
Extremely urgent matter.
What is the extremely urgent?
My lord, I have been made unsuccessful in the technical bid. All
The technical bid was open. The writ application. When the finance will be going to open?
this Friday, 14th August.
Thursday.
Date, my lord.
Appearing in person, my lord. My name has been deleted from the electoral roll, my lord.
You are appearing in all matters. Why you are appearing in thousands of matters? I pass an order.
Yes, my lord.
Then
My name has been deleted from the electoral.
you are appearing so many matters.
Yes.
Taking the order on in your case, you are not filed an application here.
Yes, my lord. Already I have filed, my lord. And in this matter, my lord, Mr. My lord.
Yes, call the list.
My lord, in this matter, my lord, Mr. Appear, my lord, and he will be available, my lord.
Lord, item 1, my lord.
Yes, who is appearing item number 1?
My lord, item number 1, my lord, I am it for the applicants.
What?
But here is the, my lord, the restoration application.
A restoration application to be mentioned? No, application.
It's under the application. Can four.
Selling slip, but you could have, no. If it is an application, it come under the application. I might be because so many mentioning list, you apply your mind.
Yes, yes.
Fix tomorrow under the application.
Under the heading application.
Yes, next.
My lord, this matter, no. Can 3 and 4. 1, you got to weird.
Item number 2 is appearing.
My lord, I am appearing on behalf of the state respondent. My lord, in paragraph number 3, there is a 76th meeting recorded, my lord. It instead of 76, it will be 77th, my lord. That is the small correction.
The matter is listed as to be mentioned for correction in the order dated 4th August 2026. Land Council appearing for the state submit that in the order dated 4th August 2026 at paragraph number 2. The instead of 76th meeting, it should be read. It should be 77th meeting. In view of the submission made by the counsel for the petitioner, counsel for the state, in the order dated 4th August 2026, at paragraph 3, line number 2. Line number 2. It should be read as 77th meeting instead of 76th meeting. This order we read along with the order dated 4th August.
The matter is fixed tomorrow.
Yes.
And
Next.
this is that matter where I am there in the custody for last 21 years.
This one.
Yes.
Come to me.
What is that?
I've served the added respondent also. Grateful.
Item number 3, your
My lord.
lordship.
My lord, this matter mentioning for the non-prosecution but listed as a correction, my lord. Matter is filed for the expedient disposal of the appeal and appeal already decided, my lord. That's why, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petition submitted. Appellate tribunal already decided the issue by including the name of the petitioner in the voter list. Accordingly, the writ petition has become infectious. In view of the submission made by the counsel for the petitioner, WPA number 13582 of 2026 is dismissed as infectious. Next.
I appear for the state in this matter, my lord. It was mentioned at the instance of the petitioner.
Yes, who is for the petitioner?
No, I believe the necessary correction would be in the first paragraph. My lord, that would be the date of the lease deed. When I have, my lord, looked into that, my lord, the date of the lease deed, my lord, is appearing as, lordships will find,
25th November 21.
yes, it would be, my lord, 1991.
1991. Yes, 25th November, October, or November.
November. It would be 25th of November 1991, my lord, as is there in the.
The matter is listed as to be mentioned for correction in the order dated 21st of July 2026. Counsel for the state submitted in paragraph 3, line number 2. The date of the lease deed is 25th November 1991 instead of 25th November 2021. Accordingly, in the order dated 21st of July 2026, paragraph 3, line number 2, the date of the lease deed shall be read as 25th November 1991 instead of 25th November 2021. This order be read along with the order dated 21st July.
Your Lordship, I am appearing on behalf of the petitioner.
Next.
Your Lordship, I am appearing on behalf of the petitioner, Your Lordship.
Yes. Item
In
number
the-
5, I appear for the petitioner, my lord. This is my affidavit of service. This application, my lord, has been filed for amendment of the writ petition, my lord, in terms of liberty granted by the Honorable Division Bench, my lord, with a order dated 22nd April 2026. My lord will find that order at page 136, my lord. This writ petition was initially dismissed, my lord. That order was challenged by the petitioners before the division bench.
Page
136, my lord. It's an order dated 20th April 2026.
136.
136, the division bench order, my lord.
No, 136 is the
139, page 139.
Sorry, 139, my lord. I
36 the single bench.
I apologize, 139. But the 136 is the order by which my writ petition was earlier dismissed, my lord.
By this court.
Yes, my lord. By coordinate bench. On the ground that the consequential order of cancellation, because of that, my writ got infructuous. So 139, my lord, the honorable division bench takes up the matter. And if my lord sees para 7 and 8, my lord.
Where is the schedule of amendment?
Yes, my lord. The amended writ, my lord, is at page 142, my lord. It starts at 142. And we have indicated what are the amendments, my lord, from page 152, my lord. 142 is the writ petition. We have annexed it entirely. Page 152, my lord, will find in red ink what are the additions which we want to incorporate, my lord. Similarly, my lord, at page 158, we have added another prayer also, my lord.
No, kindly come to page 54.
Yes, my lord.
Being agreed and dissatisfied with the cancellation order passed by the respondent, the petition have caused amendment to the prison on the ground. So this you want the ground wanted to incorporate in the grounds or what?
Yes, I want to incorporate grounds on which I am challenging the cancellation order as well, my lord.
So grounds, how this ground 1, 2, 3, 4? What are the grounds in the main writ
The main writ petition, my lord, takes page 150, my lord, para 23.
150.
150, yes, 150, my lord.
Ah.
Para 23 is where I indicated the grounds
Correct.
which I had challenged the original reasoned order, my lord.
So you want to delete this ground?
No, both the grounds would be
So
perhaps
you want to then its number will be changed.
right. I will accordingly incorporate.
154.
Yes, my lord.
No, 154. Kindly come to the 154.
Yes, my lord.
And kindly come to the 150, 151.
My lord.
Your last, the original writ petition, the ground is only 8 grounds.
Right.
Correct.
Right.
Then it will be 9, 10,
9.
11, 12.
We'll make that correction, my lord.
Here in now I am.
Yes, I'll do it right here and now, my lord.
Otherwise, then. Yes.
The amendments be carried out, let an amended writ petition be served on us and let the matter come up for consideration
So my-
any day subject to
Yes,
this.
and I have made a short prayer, my lord, for a status quo order
There is
because
already an interim order passed by the honorable
The-
division bench that it shall abide
the
by the
event-
result of the writ petition. There is already an interim order.
in the event third party rights are created, my lord, I'll be seriously prejudiced.
First amendment be carried out, then you come.
My lord,
First you come complete the amendment.
because while my writ was pending, they had cancelled my allotment, my lord.
Petitioner has filed the present writ application. And present application being can 1 of 2026. Praying for amendment in the writ application. Amendment in the facts, grounds, and in the prayer portion of the writ application. Then counsel for the petitioner submit that initially the original writ application filed by the petitioner was dismissed by the coordinate bench of this court and being agreed with the said order, the petitioner has preferred an appeal before the Honorable Division Bench. And by an order dated 20th April 2026, the Honorable Division Bench has disposed of the appeal by passing the following order. 140, paragraph 7 and paragraph. Okay. Good. As per the liberty granted by the Honorable Appellate Court, the petitioner has filed the present application for amendment in the writ application. And counsel for the respondent submit that as the Honorable High Court, Honorable Division Bench has already granted liberty to the petitioner. Accordingly has no objection if the amendment is allowed. At the land counsel for the respective parties peruse the matters on record. This court finds the amendment as sought for by the petitioner will not change the nature and character of the writ application, and this amendment application is filed in as per the liberty granted by the Honorable Division Bench. By an order dated 20th April 2026. Accordingly, prayer for amendment in the writ application is allowed in terms of the schedule of amendment as mentioned in page 152, 154, 155. Then 157, 158. This could find that in the original writ petition, there are altogether how many grounds? Eight grounds. Now the petitioner intend to incorporate further grounds, but in page 154, at the schedule of amendment, the petitioner has mentioned the ground number 1 to 11, but that should be ground number 9 onwards. Accordingly, the petitioner is granted liberty to correct the serial numbers of the ground at page 154 and 155 in course of the day. After the amendment is carried out by the petitioner, comma, the amended writ amended writ petition be filed within 2 weeks. 2 weeks after serving the copy to the learned counsel for the respondents. Respondents list the matter on 9th of September 2026.
Great. My lord, may I make one small proposal if affidavits can be called for and the matter can be decided finally, because this is a,
First you complete, if it come on 9th, I will direct.
so 9th will it come under the heading?
Ninth.
Urgent motion, my lord.
Under the same heading.
Very good.
Can disposed of, huh?
But I'm moving this petition with notice.
State respondent, my lord.
Yes.
Now, the petitioner before lawsuits have all been appointed as enumerators and supervisors. My lord, enumerators are working for census under the supervisor. Now, my lord, your losses, kindly have a look at one appointment letter that at page 37.
Page
37. Now, this work will be starting your losses from the
a surveyor for the taking the census 2007. 27.
house listing and the house
Listing and
census.
housing census. Yes.
Well, training is completed. We have undergone the training. Now, from 16th August, this work will start, and presumably this will continue for 1 month. Now, we are all teachers. Now, I will take your losses what my duty is actually, but before that, your losses will find page 44. This is the impugned order. This is 3rd August 2026. This has been passed by the Joint Director School Education to all the school authorities, DI, chairman of the councils. As directed, it is to inform him that census work should be done in such a way that academic activities in the school are not affected. The teacher may perform census activities post-class hours or during the weekends. Our class hours from 10 to 4. Saturday, half class. Now, I have to do the job after 4 p.m. It cannot be right up at 4 p.m. It might be from 5 p.m. Now, I give an example to your lordships. If your lordships kindly, then I will take your lordships my nature of duties. He is one of the petitioner. Oh, no. Just kindly page 47. By this time, I hope your lordship has come across the name of Kakinada, Barakpur, all that. Now, my residence is at Kakinada. This at least 40 to 50 kilometers away. My posting is at Taltola, near Sialda of this city. Now, thereafter, I have been appointed, as I shown to your lordship, page 37, under the Calcutta Municipal Corporation. I will come out from 7 o'clock in the morning, attend 10 o'clock. My duty is 4 o'clock up to 4 o'clock as a school teacher. Then I have to start duty at 5 o'clock. Now, at what time I will do it? In the Calcutta city, your losses will find, I'm giving an example. There is a campus. There are four blocks of in the that particular campus or a unit of flats. Now, I have to do 200 house listing or household. Now, the total campus is taken into consideration as 1. But if you is going to it, there are 500 households. I have to go from 1st floor to 10th floor. In the night, I am a lady, and I have to do during after school hours. Now, what happened, your losses? I have faced certain difficulties already at the time of training. Now, I give your losses my duties. My lord, I have narrated, and that's at page, my lord, page 10. Then I will take your losses. What the other state is doing in this sortability situation when the teachers are taken into consideration for a census. Paragraph 6. I will show from the documents also.
Yes.
The petitioner states that the census is not, assignment is not a casual desk exercise. The petitioner states that the enumerator must become familiar with the allotted house listing block, approximately 200 buildings. Each building may contain more than
one census houses, verify its boundaries, number buildings, census houses, households, prepare, update the layout map, visit every building, census houses, and household without omission or duplication, identify respondents, collect the prescribed particulars accurately, maintain confidentiality, make report visits when residents are unavailable. Well, suppose I visit a house, they are unavailable. I have to go again. Then you should find resolve locked house, doubtful cases, perform application based the data entry, synchronization, submit records, and respond to scrutiny by the supervisor. Now then everything I have to submit before the supervisor, he will scrutinize it and I have to attain her. Kindly see the paragraph 7. The operational duties are geographically and temporarily dependent. That the household members are frequently away at work during ordinary daytime hours. But pause here for a moment. Like me, the household, my family members, they are also working. They have to come back at after 5 p.m., 6 p.m., 7 p.m. I started today at 9:45 for Goriahat, my house. Now I reached your losses 10:25 because of jam. So if I go even stop at 4 p.m., immediately after duty, which is not possible physically or feasible, then even then I cannot have those household members, but I have to do the entire work of the school. Then your losses will find tenants, migrant workers, elderly persons, persons with disabilities, households in gated, scattered riverine or remote locations may require planned visits. But there are petitioners who are coming from the village areas. A single unsuccessful call does not discharge the enumerator's statutory responsibility to secure complete coverage and are duty bound to make revisits in case of failure to discharge their duties as enumerated on the first visit itself. If there is the head of the family is absent, in fact, the enumerators are duty bound to revisit household numerous times, if required, as per demand of the members. And I have to complete this work within a month. Now, this is the thing. Now, I take your losses, kindly these documents. I hand up to your losses. What the other states are doing. Well, kindly excuse me if there is any marking. I am giving to my learned friend also.
Central Union of India.
Union of India. I am giving them my copy. Well, kindly have a look at that. Allegation to other against Hanoi. Kindly see this has been issued by the government of Puducherry, the first one. Got it, your losses?
Yes, yes.
Now, this is also your losses. Kindly see Census 2017, Phase 1, House Listing and House Census. 31st May 2026 issued. Now, kindly come to 4. All details I am not taking about right now. In view of the above statutory obligations, all heads of departments and heads of offices in Puducherry, Mahe, Yanam are hereby directed to strictly comply the following instructions. All personnel drafted for census duty, field trainers, supervisors, and enumerators must be relieved from these duties to enable them to report to their respective centers in their respective batches. But therefore, they are relieved from their regular duties. I'm asking, I've been asked, go every perform.
No, whether your training is completed.
Is completed.
So all persons drafted for the census duty must relieve from their regular office duties to enable them to report their respective training center. It is a training.
This is training center. What happens to that? Now your losses will like next page. The period of absence shall be treated as on duty. Section 15A for all purposes. No separate attendance in the parent department is required during this period. Then your losses kindly see in the next page. This was from the district Puri, Odisha, to the district education officer. Subject request for granting relaxation to teachers engaged as enumerators and supervisors from school duties in connection of numbering of houses starting from 16th to 18th April 2026. But kindly see the last paragraph. This is not training. This is enumerators working. You are therefore requested to grant some relaxation from school duties to the teachers engaged in census 2027 activities for the above 3 days for the smooth completion of house listing operations. This is we are doing, we have to do, my lord, from 16.
No, আমাদেরটা আরো একটু পরে হাউস লিস্টিং আমাদের হয়ে গেছে
House listing,
ম্যাপটা হয়ে গেছে এবার
map, my lord, map is completed. Now we have to do the actual work, household work. Training completed hours. Then your losses will kindly. Next one is Hindi language, my lord. We have translated it. Very next page. My lord, this is also a losses will find, and this is from Gaya district, my lord, Bihar. My lord, kindly see, my lord, the third paragraph. This is also census 2027. Accordingly, you are hereby directed that after completion of the training period, the designated enumerator supervisors shall remain present in their respective allotted areas. Their attendance shall be recorded as mark on duty. But why I'm saying it, as soon as I have been engaged as an enumerator, my service is under the, my lord, election department, my lord, census department. I'm not under the, for the time being, my lord, the parent department.
final action আছে
I will take your losses to that. Just kindly see, Government of Odisha, next page. This is additional secretary to the government, to all district education officers. Mandatory participation of school teachers and staff in census 27 operation. I am directed to inform you that the first phase of census 2027 is currently going on in the state, and it is expected to be completed by 15th May 2016. It has come to the notice of the government that some private school authorities are preventing their teachers and staff from discharging their duties as enumerators and supervisors. Since census duties are statutory functions under the Census Act and census rules, any interference in this process is a serious violation of government duties. You are therefore requested to issue immediate instructions to all school authorities, government and private, under your jurisdiction to ensure that all staff members appointed as census duties are relieved to complete their task within the stipulated time. And no teacher staff shall be restricted from performing these duties. Well, it is not a fact that all the teachers of a particular school have been appointed. Not all. Suppose in my school there are 6 teachers, 1 have been selected.
প্রাইভেট হচ্ছে আমাদের প্রাইভেট
And in our state, private teachers of the private schools has not yet been appointed. This is my own instruction, I'll say. Then your losses, kindly see. This is your losses, Haryana in 2021. 2011, sorry. But this being followed by governments. Kindly see the last paragraph.
Who is appearing for the state?
I'm the state.
State. What is
It's
the,
really impossible.
what is your instruction?
Actually, I did not get any instructions. My lord, what I am praying, my lord, I shall lordshiply give me leave to file an report in the form of evidence. My lord,
But since when 16 August it is time
yes,
going to be started.
but unfortunately, these are not in the records.
What?
It is
That's correct. See, that leave aside. See, you also in practical difficulties be seen. The teachers are coming from 40-60 kilometers away from
Yes,
their
yes.
house to perform their duty. So they have to start from their house 1.5 hours before.
No, I appreciate the difficulty.
Just a minute. And at 4 p.m. the duty is completed. Then reaching to their house, it will about 7 p.m. So when they will complete their work, how much time they will spend for the work?
Exactly.
And in the
Correct.
night, my lord.
And it is not the total teachers have been engaged. If suppose in the school there are 30 teachers are there, out of 30 might be 10 or 20, 10 or 8 or 5 teachers have been engaged. So your school can make for this is for the 1 month period. The 1 month period, you make an arrangement for the teaching staffs for alternative.
Well, this
whatever
has
it
been
may.
followed. I'm saying in case of seal.
Everywhere.
Yes, lordship.
So you give the instruction to the authorities. Otherwise, then court has to pass a mandamus on that. So you take the instruction. So relax as per the other states. Leave aside the other states. You're not. But see the practical difficulties. The 1 month period they may be sent on duty, and for their absence cannot be absent, and they will not ask for any leave this period unless and until competent authority found that it is necessary. Second thing, for the absence of these teachers in the school, the other teachers who are in school, some arrangement may be made.
That's Lordship,
Correct.
Lordship,
So this will be better.
Lordship.
So that your work can also be complete. School, the study of the students will not be hampered, and matter can be solved.
Yes.
Okay. So
I
can,
appreciate.
tomorrow?
No, my lord.
We are on 11th. So come on 13th.
Lordship, in the meantime, it may not possible. Lordship, what?
I don't want any affidavit. You only come with the written instruction. You sent the email what the court has given the idea, and take your come on 13 because the 14, 16 from 16 is the Sunday, 17 the work is to be started.
At least, my lord, 1 week.
No, one week, then they have to work. Then it is the census work. Then they will be liable for the disciplinary proceeding. They will not.
Can you give that protection? Well, I am drawing a license. Can you see section 15 capital A of the Census Act?
That's why I'm telling you, come on 13. Don't want the affidavit. Only take instruction with regard to the alternative arrangement for the teachers who have been assigned. They may be allowed to go outside during duty.
And I should be treated as on duty.
Duty.
I have to do
He should be. He should be. That person should be treated as duty.
But your informed order doesn't say so.
Saying that they have to perform their duty 9 to 4. Then after that, or Saturday, Sunday. So 9 to 4. If it is a small area, I can appreciate. It is a small village. The petitioner is posted in the same school, and the 3 p.m. the school is over, and he will go to the village and he will do the. But here, this is not the case here. The petitioners who are posted, they are coming outside.
All of them, my lord.
If it is the same village school, then there is a different aspect.
Can you keep it on 14th?
14 is the last date. If you will not come, then
no. I shall.
Well, kindly see section.
I shall try and this much I can say.
15 capital A. As you also got it.
Yes.
No member of the census staff, I am now census staff, shall suffer any disability in service by reason of his being on census duty.
Correct.
And the period spent by him on such census duty shall be deemed to be the duty under his lending employer. And any duty performed shall not in any manner affect the right of promotion or other environment.
Nothing.
So, my lord, I should be treated as on duty. This is the object of the act itself.
Yes. I appreciate.
Please suit to that.
I shall take instructions.
The counsel for the petitioners has argued the matter.
Police
and counsel for the respondents place for time to take instruction. Accordingly, case is adjourned. Let the matter appear on 14 at
the state.
Affidavit of service kept with the record. Come on 14 at the top. First matter, I will take this matter.
Some
I'm grateful.
reasonable modalities they have to follow.
Yes,
come with
not that. I appreciate.
You are given that document. You also
Yes, I have given. It is therefore guidance that what is being followed in the other states.
Yes, next.
Item number 7 and 8.
7 and 8, last occasion, I had made some submission. This was with respect to a particular notification whose benefits the petitioners are entitled to. But till Honorable Supreme Court, it has been held already that the benefits are being granted to the casual employees. My lord is taking up 6520 first plot.
Yes.
Lord, may I take your lordship one after the other, just for the sake of recall, my lord.
Yes.
Kindly, my lord, first comes to page 26.
All are can application I finding here.
Lord, there are 2 can applications, Lord, for addition of party. 6520. Lord.
Yes, page number
6520, page number 26. This one I had right.
Your application is disposed of. Yes.
Lord, kindly comes to page 26.
Yes.
Lord, the Barashat PH division is writing to Lord the Dattapukur Gram Panchayat not for seeking engagement on daily basis guards personnel for not guarding the pumping station. Based on this, not kindly comes to the next page 27.
No, what is this?
Lord,
Monthly wages bill of 13 only for day.
Yes, at that point of time, Lord.
Engagement of the daily wages.
Yeah, on daily.
Guarding personals on behalf of the panchayat. Okay.
So this was basically under the water supply scheme.
Okay.
Your Lordship finds that in the first paragraph, third line.
Yes.
Lordship has seen that. Now, Lord, kindly turns over to the next page. Your Lordship would find the name Pradeep Kumar Vishwas.
Pradeep Vishwas, yes.
Lord, he is petitioner number 5.
Yes.
So I shall not disturb your Lordship with all the petitioners. I'll just take your Lordship to one. The remaining follows. All are same.
Yes.
Now, Lord, he was appointed by the Pradhan based on that notification.
Yes.
Thereafter, your Lordship would also find Lord, the other
1998.
This is 1997.
Signature is Pradhan is 98.
Not that 2nd of, oh, I'm sorry.
Second of
I'm sorry.
97,
Yes. 2nd of
Signature is
April.
98.
Yes,
We don't know what is 98 or 97.
But the date we have your Lordship is 2nd of April 1997.
The top 97.
Yes,
but
the
signature
signature is on
98. Whatever it may be, yes.
Now, Lord, since then, he has been Lord, performing his duties. Based on this, your Lordship would find kindly comes to Lord, page 32.
Yes.
This is the I-card Lord issued.
Yes.
Lord, I understand, Lord, although the signature is 98, your Lordship would find Lord, the date of joining is 1997 only. And Lord, this particular card was issued, Lord, if I'm not mistaken, on 2008. 16th of December 2008.
Page 30?
No, 32? 32?
Page 32, 2008, yes.
Yes, 2008.
Yes.
And Lord, thereafter the other I-cards are also there, 33 onwards.
Yes.
Now, Lord, kindly comes to page 37. This is the first notification of its kind.
Yes.
It has come to the notice of the government for some time past that the implementation of various schemes of various departments, the controlling authority have been compelled casual daily rated workers. In many cases, these employees render service for a substantial period of time, even for more than 10 years, remaining attached to various departments of government. The issue of security of tenure, appropriate emoluments, and certain retirement benefits in respect of these employees so engaged on long-term basis has been under consideration of the government. So that was the basis, background. After careful consideration of the matter, the governor has now been pleased to order the casual daily rated workers who are remaining attached to establishments of government departments, directorates, regional offices for not less than 10 years as on such and such, not 1st April 2010, very important date, and have rendered services for 240 days each year will be allowed the following benefits. Now, the benefits are there. I am not taking your Lordship to the benefits because these benefits have been changed from time to time. So, this was the background. When this was passed, there was a difficult situation which arose regarding whether this particular notification will be applicable to panchayat and other municipal authorities.
Yes.
To clarify that, kindly comes to page 39. With reference.
Yes.
With reference to above, the undersigned would like to state that sometime past, the office has been receiving several representations from panchayat guards engaged in different water supply schemes such and such. In this context, it may be stated here that one writ petition was filed before the Honorable High Court Calcutta by 3 numbers panchayat guards for same issue, and same was disposed of as such and such. 11 selection committee, after taking hearing, the decision. So, it was stand at that point of time. Kindly comes to page 43.
Yes.
This entire, my lord, dilemma was completely cured by this notification. In order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to casual delimited contractual workers. My lord, what is important is not the oblique used. So, my lord, casual delimited or contractual workers who have remained engaged in various government establishments for a considerable period of time, the more than 10 years in connection with implementation of various schemes and projects. Government memo 2nd of December 2020 were issued by the government. The question of making the provisions of aforesaid to more effective and suitable to convenience of the government establishment or organization has been under active consideration. After careful consideration of the matter in supersession of other aforesaid orders and all other orders issued by other departments in the matter, the governor has now been pleased to order that casual delegated workers who are attached to such and such government, regional, other organizations of this and this will get this benefit. Straight away comes to Lord, page 45, Roman 12.
Yes.
The benefit of this memo will be applicable to the panchayat bodies or urban and you will be so this will be urban land bodies or statutory bodies, not all municipal bodies basically. The casual 1st April 2010 as cut-off date the benefit of this and this memo, and thus all the previous memos were made applicable.
Yes.
Now thereafter, one after the other, page 48, 50, 52, and thereafter another notification is there. Not all notifications have only extended the benefits with time. The basis remains the same. Now this particular benefit was not being granted to the panchayat guards despite repeated representations. Now we came up before this honorable court. Now this honorable court, page 56, kindly comes to page 56, Lordship Singh gave that, passed that order, the honorable single bench. Page 61, is the order of division bench. Affirmed.
What the single bench?
So the single bench held specifically, kindly straight away comes to page 59.
So, page 16, paragraph 16.
Paragraph, I'm grateful. Paragraph 16 and 17. So this became applicable. All these circulars became applicable. And directions were made to pay. Namlot kindly comes to page 61. The state filed the appeal. Now, 2 appeals your lordship would find because 2 batch of writ petitions was there. But kindly straight away comes to page 74.
Yes.
Accepting respondent number 25 in such and such, entitlement of all other writ petitioners to receive the benefit that have been extended under memo such and such cannot be doubted. Therefore, each of such writ petitioners have to be paid their dues in accordance with such and such. In addition thereto, we direct that the appellants will have to pay interest at the rate of 6% per annum from the date of accrual of such benefit. So, interest along with the arrears were granted. The state being aggrieved by this payment of interest, went up to the Honorable Supreme Court, page 77, the Supreme Court had dismissed the SLPs.
Yes.
So, it is no longer res integra.
So now what your prayer here?
Lord, my prayer is I stand on the same footing.
So you are not the petition there.
Lord, all those have been said. I stand on the same footing and Lord, kindly, Lord, considers this judgment. This is 2024 SCC Online Supreme Court 3664.
Yes.
That here also certain benefits were granted, and Lord, some of the Lord petitioners who were not parties Lord in that proceeding,
Wrongly
it
excluded.
was told. Paragraph kindly come to Lord, paragraph 10. 2024 SCC online SC 3664. May I please it for your lordship?
Yes.
Paragraph number 10. At the outset itself, it may be we may say that the phrase only to petitioners in the order rejecting the representation is patently erroneous. While the AFT principal bench granted relief to petitioners and it did not prohibit the department from considering similarly situated persons, another representation was disposed of on such and such interiorly on the primary ground that she did not meet the criteria. In the meantime, the appellant's services were further extended for a period of such and such. The appellant thereafter kindly comes to, this was the basis, kindly comes to paragraph number 14. It is a well settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his favor, others similarly situated ought to be extended the benefit without the need for them to go to court. So, Lord, I being, and not thereafter 20, your lordship would find the order was directed not to be complied.
23.
20 and 23. 20 and 23. So, Lord, my prayer before your lordship is, Lord, that I am on a similarly placed footing. I cannot be debarred for frivolous grounds. Kindly now, Lord, sees they had used Lord report. A report was directed to be filed.
What is that stand?
Their stand in the report is first that Lord, the same old stand that we were not sanctioned, our posts were not sanctioned, so nobody will go to, is going to take responsibility.
What is the status today of your petition?
The petitioners are working, still as yes.
As a guard?
As a guard. And bills are being raised, salaries paid, we have annexed the salary slips also. And the latest, the names your lordship would find, one after the other, we have annexed in the affidavit to the exception.
Where is the affidavit report?
Yes, Lord, kindly comes to report. Now, 2 reports were filed.
May I place my report?
About other report.
No.
He telling that he will place the report instead of you. So you should not take the trouble of the report of the authority.
There are 2 reports, Lord. One is the main report, the other one is a supplementary report. The supplementary report is dated 13th of November 2025.
Let me check. Where is the report?
It is Josh Saab ke ber kore dao.
Report, perhaps it is not with the judicial files, perhaps.
File hai nahi.
Earlier occasion, on earlier occasion, it was told that supplementary report was filed. Somehow, it is not there. The assistant counsel contacted with the state of Ilkis, they served us a photocopy of the same. Kindly as original. It is not.
There is what is the date of 13th April 20?
The first report.
There are 2 reports, na? There are 2 reports.
One report is 23rd of June 2025. Yes. And the supplementary, I think, Lord, my
13th April 2020.
13th April. 13th November.
It is a November.
13 November 2025. These are the 2 reports Lord submitted.
Yes.
Now, Lord, kindly comes to page number 4 of the main report.
Yes.
Lord, a comparison was
page number 4.
Page number 4, internal page number 4. Lord, a comparison was directed to be made between how Lord these Lord petitioners are differently placed than the Lord petitioners who had obtained the benefits. Tapan Kumar Mondal, Ruthin Ji, Pradeep Kumar Vishwas. So these are the first 5 petitioners. And not 6, 7 and 8. Not they are the petitioners in the other writ petition. And not the added respondents, your lordship would find 9, 10, not 11 through 15. So Lord, these are the status. Now Lord, may I read it out for your lordship, Lord, what is the difference? The judgment, Lord, the first column consists of the previous proceeding. The judgment of order dated such and such passed by such and such. This court is of the clear view that the petitioners are casual workers. The honorable judge accepted the submission of the learned advocate for the petitioners that the engagement is casual, worldly, and has been done primarily in case of petitioners and many similarly situated persons, because there is in fact no sanctioned post of the security guards either in the PHE or in the Gram Panchayat. On an appeal being preferred, not such and such contractual engagement, these were not, I've already placed it, so I'm not repeating. Kindly now takes the second on the right hand side the column dealing with these 2 present writ petitions. However, in the instant case, there is apparent evidence on record of the petition that the petitioners have been engaged as daily wages, similar admission, guarding personnel such and such as would appear such and such, and according to their engagement letters were concerned. Second, the petitioners in the present writ petition worked as daily wages guarding and not on contractual basis, not completely irrelevant consideration. Furthermore, the petitioners hearing guarding personnel by concerned Gram Panchayat municipality and bills are also placed from the concerned Gram Panchayat municipality to PHED as would be evident from the petition such and such hearing squarely falls within clause 10 of the memorandum dated 16/20/11. This memorandum date is also, I suppose, is incorrect. It should be September 16, the one that I had shown to your lordship, which appears at page 45, if I'm not
Contractual
mistaken.
engagement.
But he says that they are not contractual engagement. And first, he holds
10 says,
yes,
the provisions of this order will not be applicable where the contractual engagement has been made without any sanction.
Now, Lord, if that is what the contract clause 10 says, his admission that we are not in contractual basis, not on otherwise sanctioned post, Lord, all these aspects were duly covered and considered. The same line of argument was made till Supreme Court.
Yes.
Now, Lord, and in supplementary report, they wanted to develop on the bills. The only difference your lordship would find in the supplementary is that the bills have been generated by Panchayat. In the other writ petition also, all bills were generated by Panchayat. Well, that's the reason I showed to your lordship that the appointment was made at the instance of PHE, but appointment through Panchayat, and not by through Panchayat the bills were sent, and through HRMS not the transfers were made. This is how the entire thing functioned. Remember, this aspect again came for consideration recently before this honorable court. After this orders I have placed was passed. The order tadi copy. Arakta. একটা মিনিট আমি শেষ করে নি Lord, this
actual what was the point that has not been argued by your advocate in the earlier litigation?
While at that thing, I tried to scrutinize the entire writ petition, including the report. Well, the thing is this, that if I want to get a service, suppose 2 conditions are there. You have to pass secondary level examination and you have to secure 80% marks.
When that recruitment came into force?
No, I am trying. So you have to secure at least 80% marks and pass secondary examination. 4 things are required. If 2 things are not there, simultaneously, I cannot debate can be continued. There is any sanction clause. Debate can be continued. How they were appointed, who gives the money, debate can be continued. But for getting this advantage, two things are required. Specific two things. 10 years service. And each year
245.
40. And we come to page 40.
Let they complete first. He has not completed. I will come to you. I will hear. I will hear you. I will hear.
Yes.
This point.
Yes.
Lord, the judgment that I just handed up to your lordship, Lord, is an unreported judgment.
Yes.
Bhim Kumar Gain versus State of West Bengal.
Yes.
The petitioner's content, Lord, the same argument. The petitioner's content on the same notification. Your lordship finds, Lord, first paragraph. Second, the same, Lord, 10 years completed, 240 days, such and such. Lord, on basis of, Lord, this judgment that I just cited before your lordship, it's there. Upon going through, Lord, 1920, that's there. There is no dispute that the petitioners were engaged as casual daily rated workers in different districts, and thereafter, Lord, directions were passed, Lord, to pay and disburse them. So, Lord, it has been followed recently also. Now, Lord, the only thing, Lord, kindly comes to paragraph number 8
of your writ petition.
Of the writ petition.
Yes.
But I have specifically stated that the requirement is 10 years to 40 days. Your lordship would again find that in Lord paragraph number 10, paragraph number 11.
Admitted. They have pleaded this. This is admitted.
And it is nobody's case, even if the report, it is nobody's case that I have not completed 10 years of service as on 2010. Today, 10 years not relevant. Not in 2010, I had completed 10 years of service with 240 days each. So it's nobody's case that I have not. Till date, I am receiving whatever I was receiving, and my kindly takes my affidavit of exception. Kindly comes to
which one?
Affidavit of exception is dated 15th of July 2025.
Yes.
I have not specifically dealt with each and every comment that I had made. Kindly comes to paragraph number 3. This I will not read it for your lordship because I have already placed it. Kindly comes to page number 9.
Yes.
Kindly sees this is how Rothin Pike, item number 6, serial number 6, 7 Tapan Kumar Mondol, 8 Prabir Kumar Banerjee, 15 Pradeep Bishwas, 17 Kiran Kumar Ghosh, 25 thereafter page 10 Sheikh Bin Mohammed, and 32 Mohammad Zulfikar Ahmed. These are added respondents although. Lord, in the other writ petition, I have also used an affidavit of exception. There, I have indicated this kind of a list where page number 9 itself, serial number 89 to 92 and 94, the petitioners and the added respondent, your lordship would find. So, as on date, the latest of the whatever the chart is about the employees, my name surface. Till date, I am drawing the salary. Till date, I am drawing the salary. So, there is no dispute that there was ever any break of service, there is ever any dispute that I have not concluded 10 years of service or 240 days in a year. No complaint whatsoever.
Yes.
So, my lord, the only defects that today surfaces before your lordship is, my lord, I have to complete 10 years of service and 240 days.
Per year.
Lord, that is not taken anywhere, not nowhere in the representations.
Okay, let me hear.
From the last line of his argument, I will initiate my first line of argument. If I ask you have to produce a certain document, if you have to take your benefits, you have to produce that document. Well, it kindly came page 43 of their there is a debate whether the sanction rules are there. There is a debate who is the appointing authority, but there is no debate. You have to complete 10 years of service and 240 days. These 240 days is very important because we do not have the ground surveillance whether 240 days is actually they performed or not. That is my case here.
You know, you know how the 240 days has come.
I am placing my case.
How the 240 days?
That has to be certified.
How 240 days has come? You know why the authorities are harping upon 240 days?
Because some views are there.
That's why I ask you. The initial stage when the writ petition was taken up for hearing, you state authority missed the bus. Kindly see the 25 of the Industrial Dispute Act. And if the Panchayat and this PWD, they are the industries. If they are the industries, and if the person intending to be regularized, it will go to the conciliation officer. The conciliation officer has to decide the matter. If the conciliation officer failed to decide the matter in favor of the petitioner in terms of the guidelines, then under section 10, it has to refer to the administration. Then the administration will refer the matter to the labor court. Then the labor court will decide what you are raising the objection that has to be proved by the petitioner during the evidence under the before the labor court. But that you missed that.
Most of this, now I am facing most of this. That is why we are learners, and that is why the honorable judges are there. That is why we are the learners.
Not. We are getting from you and we are giving to you. That is not that we know all the things and you are learning all persons are learning every day.
Well, it says, para 3, I am starting from para 3. After careful consideration of the matter and in supersession of the aforesaid order and all other orders issued by the other departments in the matter, the undersigned is directed by order of the government to say that the government has now been pleased to order that the casual daily rated contractual workers who are remaining attached to various establishments of the government, department, directorates, regional offices, other organizations for not less than 10 years continuously, as on such and such, and have rendered service for at least 240 days each year, will be allowed the following benefits. Now, my lord, the thing is this first Roman one, the casual daily rated contractual workers who have rendered 10 years of service continuously with at least 240 days attendance each year may remain engaged in the same status and capacity till they are attaining the age of 60 years. My case is in the next paragraph. The continuity of service shall have to be certified by a competent officer not below the rank of assistant secretary in the case of secretariat department, director in the case of a directorate and assistant engineer, SDO, BDO in the case of regional offices. The concerned officer who certifies may be advised. This line is very important. The concerned officer who certifies may be advised to exercise extreme precautions and take assistance of an office of WDA and AS if necessary. That line is key.
Correct.
There is a distinction.
Correct. Whether have you taken their representation is disposed of, their request is disposed of.
Supplementary report, they have raised, government also raised the issue also. Well, it kindly comes
So,
with
so
two.
that's why if you raise the issue, so let you consider, then you decide they're not 240
Yes,
days
yes,
not
why not
completed, when you consider
not
disposed of, nothing remains, because you have to act in accordance with the memorandum. Correct. The petitioners are demanding for implementation of the memorandum.
Absolutely.
Now they have some weightage with regard to the order passed by the honorable single judge as well as the division bench. And correct. So now you have to follow the guidelines in consonance with the order passed by the court. Now, at the time of grant of benefit, in terms of the memorandum, you have to follow the guidelines. So, if the petitioner forwarded all these things, then if it is found they are the continuous 10 years, they are having the 240 days, no purpose. If the petitioner did not find the 240 days, is only worked for the 180 days or only for the 5 years, then automatically he will be debarred for getting the benefit.
And my lord, the next case is page 57. Only this is my last. Page 57. The coordinate bench order that affirmed in appeal and state preferred and SLP that was rejected. There is a distinguishing feature. Earlier coordinate bench judgment and their case, para 7. The continuation, this point is very important. The continuation of the petitioner services as security guard is further strengthened in a recommendation of the chief engineer, headquarters PH directorate, recommending on such and such permanent absorption of the petitioner as security guard by the PH. The recommendation is annexed to page 5, annexed P7 of the petition. Here, no such recommendation is there. So this is the distinguishing feature.
That's why I'm calling. That's why I'm calling. So they will prove.
But what I was praying for is not only this aspect of 10 years till 2010 or whenever, and 240 days is to be considered. Not let it be time bound or not keeps this petition pending, because only this aspect is to be considered. Else, blood again consideration, again this thing.
I will pass a direction if the petitioners prove with regard to the condition 1 and 2 of the memorandum, they are having the continuous 240 days of service in a year and they are continuing working for the last more than 10 years and more, then the authority immediately follow the guidelines and release the amount, and
entire exercise to be concluded within
a period of some. If they will find, then not automatic.
Very.
Yeah, no problem. You've done your work, then you can leave the court. The petitioners have filed the present writ application praying for a direction upon the praying for a mandamus upon the respondent authorities for implementation of the service benefit in terms of the memorandum number 2966 capital F within bracket capital P dated 23rd April 2010 and all other consequent memorandum dated 22nd December 2010, 16 September 2011, February 25, 2016, 15 July 2019 and 1st March 2024. 2020. The petitioner submits that Now, the petitioner relied upon the letter issued by the Assistant Engineer Barasa Subdivision, PH, what is the PH? Page 26, what is PH? PH Engineering.
Yes.
PH Engineering Directorate, dated 27 September 1995, wherein the Assistant Engineer requested the Pradhan for engagement of daily basis guarding personnel on behalf of the Panchayat on a monthly wages of rupees per day per head as per the PWD schedule of rates, and the same may be some schedule of rates, full stop. The petitioner has relied upon the letter of appointment wherein the petitioners have been appointed as what is the post? As guarding personnel.
Panchayat water supply guards.
As Panchayat water supply guards.
And Lord, in 8, they are municipal water supply guards.
So now Panchayat water supply guard and municipal water supply guards. Full stop. The petitioner has relied upon, and full stop. The petitioner relied upon the memorandum dated 23rd of 23rd April 2010, issued by the Principal Secretary to the Government of West Bengal Finance Department, wherein the government has taken a decision that in many cases the employees render service for the substantial period of time, even for more than 10 years, remaining attached to the various departments of the government. And the issue of scrutiny of tenure appropriate enumerates and certain retirement benefits in respect of those employees so engaged on long-term basis has been considered by the government, and the governor has pleased to order that those casual daily rated workers who are remaining attached to the various establishment of the government department directorates regional offices for not less than 10 years as on 1/4/2010 have rendered their 240 days service of each year shall be allowed the benefit, which reads as follows. 8 of page 37. Full stop. By a letter dated 29th of October 2010, the chief engineer has forwarded the details of the persons who have rendered work to the Joint Secretary PHE Department. Subsequently, further memorandum was issued on 22nd of December 2010. And finally, on 16 September 2011, a consolidated memorandum was issued for suitable to the convenience of the government establishment of the organization for active consideration of the persons who are working in the government for the last several years. After the issuance of the said memorandum, even after issuance of the memorandum, the department has not implemented the same. Accordingly, some of the petitioners have filed a writ application before this court, being WPA number 8597 of 2020 within bracket Akbar Ali and others versus State of West Bengal. This court by an order dated 15th of December 2023 has disposed of the said writ application by passing the following order. Paragraph 16, 17, page 159, paragraph 16 and 17. Okay. The government of West Bengal, being agreed and dissatisfied with the order dated 18 December 2023 passed by the coordinating bench of the court, has prepared an appeal. Being MAT number 429 of 2024 and MAT number 430 of 2024. The Honorable Division Bench of this court has disposed of both the appeals by an order dated 4th of July 2024 by passing the following order. In the following order. Paragraph 27, page 74, paragraph 29, 30 and 31. Good. The government has being agreed with the order passed by the Honorable Division Bench. The government had preferred an SLP, but by an order dated 25/11/2024, the SLP was dismissed. Now the petitioners are claiming the same said benefit in terms of the memorandum issued by the government from time to time, as well as the order passed by this court, which was duly affirmed by the Honorable Division Bench. Lord, yes, Honorable Division Bench. Full stop. The only issue raised by the respondents in the present case that as per the memorandum dated 16 September 2011, it is categorically mentioned and in the present case, it is a specific case of the respondent authorities that in the memorandum dated 16/11/2011, it is categorically mentioned that paragraph page 43, paragraph 3, 4, this one, here se yahan tak. He submit that by referring the said clauses of the memorandum dated 16 September 2011, submit that if the petitioners are not completed 240 days in each year and are not worked for continuous period of 10 years, the petitioners are not entitled to get the benefit of the said memorandum as well as the order passed by the Honorable by this court, which was affirmed by the Honorable Division Bench. He further submit that the order passed by this court, which was affirmed by the Honorable Division Bench, is having distinguishable fact. In the order passed by this court in WPA number 8597 of 2020 dated 18th of December 2023, in the said case, the court has noted that the petitioners the continuation of the petition noted that inward comma the continuations of the petitioner's service as security guard is further strengthened in a recommendation of the chief engineer, headquarter PHE Directorate, recommending on 9th July 2011 permanent absorption of the petitioners as security guards by the PHE. Full stop. The recommendation is annexed with at page 5, annexure P7 of the writ application. But in the present case, there is no recommendation from the competent authority in terms of the memorandum. The learned counsel for the petitioner has relied upon the judgment in the case of Lieutenant Governor Suprita Chandel versus Union of India and others, reported in 2024 SCC online 3664, and submit that the Honorable the Honorable Supreme Court has held that it is well settled principle of law that where a citizen aggrieved by an action of the government department has approached the court and obtained a declaration of law in his oblique her favor, others similar situated ought to have been extended the benefit without need for them to go to the court. Learned counsel for the petitioner by referring the said judgment submit that in the present case also this court has passed an order in favor of the petitioner, which was duly affirmed by the Honorable Division Bench, and the Honorable Supreme Court has not entertained the SLP filed by the petitioner, filed by the authorities. Thus, the respondent authorities ought to have extended the benefit of the said judgment to the petitioners, but in the present case that has not been extended. Learned counsel for the petitioner further relied upon the unreported judgment passed by the coordinate bench of this court in the case of Bhim Kumar Gain alias Bhim Gain and others versus the state of West Bengal and others, dated 2nd September 2025, wherein the similar situated person, wherein the prayer of the similar situated persons have been allowed by the coordinate bench in terms of the order passed by the coordinate bench of this court as well as the division bench of the court. Full stop. Had the learned counsel for the respective parties perused the materials on record, there is no dispute that the petitioner, the learned counsel for the petitioner further submit that the petitioners are still working in the department, but they have not been given the benefit either of the memorandums or the order passed by this court. Full stop. There is no denial that the petitioners are not working in the department or were not appointed as post. What post? Which post? As guard of water supply. Water pumps. The only dispute raised by the authorities that the petitioners have to prove that they have continued work for 240 days in a year and are also working for the last more than 10 years. 10 years. Considering the above, this court find that no purpose should be served by keeping the present writ application pending. Accordingly, writ petition is disposed of by directing the respondent authorities to consider the request of the petitioners for grant of the benefit in terms of the memorandum dated 16 September 2011 by considering the order passed by the Honorable by this court, which was duly affirmed by the Honorable Division Bench, as well as Division Bench. Full stop. If the respondent authority is having any difficulty to decide whether the petitioner will have continued work for 240 days in a year and 10 years, the respondent authority can ask the documents from the petitioners to prove their case with regard to continuous working of 240 days in a year and 10 years. 10 years, and the petitioner, if the petitioner satisfied the authorities that they have continuous work for 240 days and for 10 years, the authorities shall extend the benefit of the guidelines, the memorandum, as well as the order passed by this court, as well as the division. Petitioner as well as the added respondent. जहां भी होएगा ना, petitioners as well as the added petitioners है, added respondents होगा. I mean देखो, ठीक है. Full stop. The respondent authorities are directed to complete the task within a period of 6 months. Within a period of 6 months from the date of receipt of this order. एक ही साथ होएगा with करके
Most of it.
yes 6 7 8 both similar order. What marking? What marking?
Page one.
I am not refer the pages and pagination.
My lord, in this matter, my lord, I am appearing for the petitioner, my lord. Leave may be granted to appear online, my lord.
Samantha, what matter is there? Yes.
My lord, may I refresh, my lord, my memory, my lord? The matter is, my lord, we are enjoying an interim order that was challenged before the division bench and the Supreme Court, and it has been upheld. My lord, the facts are, my lord, the petitioners are aspiring candidates for being appointed as primary teacher. My lord, your lordship knows, for being a primary teacher, a diploma degree is required. My lord, petitioners have the diploma degree as well as Bachelor of Education degree. My lord, petitioners in the recruitment of 2022, that is the recruitment in question.
That matter with regard to the guidelines.
No, my lord, no. What happened? Petitioners applied as a B.Ed candidate. Subsequently, my lord, the Supreme Court passed an order that B.Ed is not a training qualification for primary. Thereafter, petitioner wanted that since we have also DLED, we may be allowed to switch, because when we applied, B.Ed was not disapproved. My lord, the High Court single bench passed an interim order that petitioners may be allowed to permit to accept the DLED mark sheet, and the petitioner's rank and position may be disclosed. My lord, that was the interim order. Since our interview was taken, my lord, that was challenged by the board before the division bench. Division bench, my lord, dismissed the appeal. Board preferred an SLP. My lord, SLP also dismissed. Now, my lord, the matter is before your lordship for final hearing. My lord, what we want, our interview has been taken. The point is, considering our DLED, our position in the recruitment process, and should be published so that if we come within the zone of consideration, we may be given appointment. My lord, on the last occasion, learned senior Mr. Shandal, my lord, appeared prayed for, my lord, an accommodation. My lord, on 2 days, my lord, I don't know whether he will argue it.
No, Mr. Sanyal is arguing.
Yes. My lord, these are my facts, my lord. If your lordship, my lord, kindly come to the order passed in this matter.
Mr. Dasgupta, please. Yes.
Yes.
See, the one point is required whether they can be shifted to the delete other than the bid. Yes, Mr. Sanyal, that is the only point.
And because, my lord, I have prepared an application that was
What application?
I told you, Lord, to bring subsequent facts. Subsequent facts, I indicate that. Then the process feel its necessity. When the petition was moved, the day before that panel was published, selection process completed. Only the number vacancies, 1,000 and odd, if I'm not wrong, your lordships, that vacancy is kept aside by the Supreme Court for certain candidates, only for certain candidates. Those vacancies of the Supreme Court are only for the 2022 batches only. They are not 2022 batches, meant for them only. Those 20 vacancies, when the Supreme Court contemplation was not considered, the vacancy lists were given by the board. It transpired that the most of the vacancies are for ST. We do not get sufficient number of ST. So candidates are not matching their category. So we put this. Now the Supreme Court that the government to be content. Now surrender the vacancies and then matching vacancies.
Surrender.
Surrendered.
That's the reserve vacancy.
Reserve vacancies, the categorized vacancies.
Correct.
Then the board, government gave the matching vacancies. In terms of the Supreme Court, those matching vacancies have also been filled up. The very this is, if I say so, it's a in dead child in the womb. That's all I will give the facts also before.
So you mean to say that there is no medicine also?
No medicine. So that's the point to be lordship considered. This is not because the kindly see if I'm not wrong, it's 11 February this was upon the resolution. Supreme Court the appointments were given. This was not brought to the notice, my lord, at that point of time. I also appeared, my lord. Also that. But this is the situation facts. So that process has come to an end completely. So give me a week or 2 weeks time, my lord. This is my application from the chamber of Mr. Bishwas has been sent to the board. They are checking it out.
Yes, Mr. Dasgupta.
My lord, if they want to file an application, my lord, but sir, I cannot have any objection, my lord. Only thing, the factual aspect as submitted by my learned senior Mr. Shanal, my lord, probably has not been properly.
Okay. Let the material come on record. We'll
My lord, only one thing, my lord, let the advance copy be served so that we can be ready on the next day.
Sure. How soon you will file?
Give me a copy of the vote. Just a minute. But within 10 days we will file it.
Learned Counsel, Mr. Subir Sania, learned senior advocate appearing for the WBPPE, submits that there are certain subsequent events have been happened after filing of the present date application, and as such he wanted to bring on record by way of an application. Accordingly, he pressed for 10 days time to file a supplementary affidavit by disclosing certain documents.
Well, I'm giving an application because that will exception might be taken.
Filing an application by disclosing certain documents. In view of the submission made by the counsel for the WBPPE, leave is granted to file an application disclosing the documents within a period of 10 days from date after serving the copy to the learned counsel for the petitioner. The petitioner is at liberty to file exception, if any, within a week thereafter. This is the matter. কিছু ডেট আছে কি আগে आगे पीछे ना बीच में नहीं है 17, 18, 20 सितंबर में खाली नहीं है ठीक है 14 September 12 noon.
My lord, deeply obliged. My lord, may I have your lordship's leave to go out, my lord?
Yes, sure.
Deeply obliged.
Yes, next.
May it please your lordship.
Yes.
Lord, that order which your lordship passed on 15/6, Lord, they had preferred an appeal.
Yes, what has happened to the appeal?
Lordship's order has been upheld with slight modification. 2 weeks they have to give the full complete possession and also the registration part. Lordship will direct them. The appeal court has requested your lordship to continue with the matter. So, my lordship will ask them to file a compliance report after 3 weeks.
My lord, your lordship, I appear for the housing board, your lordship.
Yes.
Pursuant to your lordship's order, a board resolution has been taken to execute your lordship's order, and we have already issued a notice to one of the flat buyer for execution of for handing over possession and execution of the registration. So it was issued on 5th of August 2026 to one Ashok Kumar Gupta. But my junior is there, will hand over a copy of the letter which we have already issued on 5th of August 2026.
You do one thing, how soon you will come, what is the time given by the appellate?
2 weeks.
2 weeks.
Yesterday, the order was passed.
So yesterday the order was passed, 2 weeks, now we are on today, we are on
11th.
11th. 2 weeks.
Yes, your lordship.
25th. So I am fixing on 27 for filing the report.
Or 7 days later. 3 weeks.
3rd September.
My lord will kindly appreciate, my lord, we have taken steps to comply your lordship's order.
I am not telling anything. I am only fixing a date on 3rd of September because this court is only wanted that the party should get some relief, which on the order passed by this court, which was also passed by the appellate court. That's only, nothing else.
Lordship, I beg some apology due to the inordinate delay, your lordship. However, my lord will kindly appreciate that this is a wing of the West Bengal government. When there was a change, but it took some time to take decision, your lordship.
You file the comprehensive report on 3rd of September 2020.
Compliance report.
Compliance report.
We'll file a report, your lordship.
Let the matter appear within the first 15 or 20 matters. Subject
counsel for the party submit that. The petitioner has the respondents have preferred an appeal against the order passed by this court dated 15th of June 2026. The appellate had slightly modified the order passed by this court and directed the respondents for handing over the possession and to complete the deed within a period of 2 weeks. Complete the execution of the deed within a period of 2 weeks. In view of the above, the respondents are directed to file compliance report by 3rd of September 2026 after serving the copy to the land council for the petitioner. Let the matter appear on 3rd of September within 10 matters.
I'm great.
Under the same heading.
Most grateful, your lordship.
Next.
Can you, lordship, this is my application.
Yes.
The last occasion, lordship, I was being led by lordship. Your lordship can just read the name.
Sir, can I transfer the matter?
No, please. Lordship will kindly just.
No, I will transfer the matter.
Lordship, my learned senior was supposed to come back with instructions. They've come up with the report. No, there is no question of an exception. I'm relying on this report.
Petition is not letter.
No,
This is with regard to recovery of the and there is arbitration clause also.
Yes, sure.
And this is covered by several judgments of Supreme Court as well.
No, your lordship, I absolutely agree with that. Lordship will kindly look at the distinction of claims. Arbitration clause not being a bar to a writ petition is well settled now.
This is
Lordship,
judgment of the coordinate range on the basis of Supreme Court.
Yes.
Yes, your lordship. Lordship, I will distinguish the judgment as well.
Cited on behalf of the respondent.
Right,
Supreme Court as well as other.
Lordship will kindly look at what is my factual matrix here. Lordship, I have disjuncted the claim in 2 aspects. One is with respect to admitted claims that they have admitted in their own correspondences is due and payable to me. The reason why that amount is not being remitted to me is, your lordship, paucity of funds, which they have also. So will kindly allow me to move my writ petition. Which they have admitted, your lordship, is due and payable to me. The reason why it cannot be remitted is paucity of funds. The other aspect, your lordship, of my claims, of course, being disputed, your lordship, I am not claiming that before this honorable court, and I have disjuncted those claims up as otherwise. Lordship, I will rely on only one document. Your lordship will kindly look at page number 279.
Sir, move
279 in volume 2, your lordship. And your lordship will kindly juxtapose that with the stance taken in the report that has been submitted by my senior.
279.
279.
Yes.
Lordship will kindly allow me to place it.
In the light of the above, we urge that the immediately arrange for the deposit of 7 crore.
Yes, Your Lordship.
39 lakh 55,000 so to enable us to clear the outstanding. It is important to note that any additional financial demand, including the interest losses arising from arbitration, will be entirely responsible for your office. Yes. Then
Lordship, Mr. Banerjee is leading me in this matter.
Same thing, what that letter I would have shown. And your Lordship has seen that one document, Lord, if I may just show, page 279.
yes.
279 actually. Oh, Mr. Lordship, looking at, kindly have a look at the last one. We urge you to immediately arrange for the deposit of so and so to enable us to clear the outstanding dues.
So this is Eastern Railway writing to whom?
To Garrison Engineer.
Garrison MES.
Straight admitted dues. And this your Lordships have now
You
considered.
are appearing for whom?
I am agreeing for the respondent, railway.
You are for the railway.
Railway.
Yes. Who is for the Union of this Union of India?
Union of India.
Railway is the answering.
You are appearing the same.
Union of India has not been made party. Defense also has not been made party.
My contract is with the railways. I have nothing to do with defense.
File affidavit of opposition to the petition.
No. See, just kindly come. Please.
There is an arbitration clause, disputed question of fact involving this writ petition, and on this ground, this writ petition not made.
Please come to page 279. Come to 279. Please come to page 279.
Apart from those documents has not been annexed. That's
Okay, I totally agree with your submission that is money claim, disputed claim. This writ court slow in entertaining the application. I totally agree with you. Kindly come to page 279. It is your letter. 279. Kindly read the last paragraph loudly.
He has also marked it.
No. That's why.
Record an order. The petitioner has filed the present writ application praying for a direction upon the respondent authorities for release of the outstanding due of the petitioner. Full stop. The petitioner submit that the respondent authorities have awarded the contract to the petitioner. The petitioner has executed the work, but the respondent authorities have not released the payment. Subsequently, the petitioner have made representation to the respondent authority for clearance of the dues pending against the petitioner. The senior divisional engineer within bracket 3 Eastern Railway, Asansol, by a letter dated 10th of March 2025, requested the garrison engineer, Panaghar Military Station Engineering Services to immediately arrange for deposit of 739555577.90 to enable them to clear the outstanding dues. It is also mentioned that any additional financial demands, including interest or losses arising from arbitration, will be entirely the responsibility of the office of the garrison engineer due to the prolonged delay. Full stop. Today, when the matter is called for, London advocate appearing for the railway authority submit that the writ petition is not maintainable on the ground that this court cannot decide the money claim, and in the agreement there is an arbitration clause. This court has inquired from the London advocate from the railway authority with regard to the communication dated 10th March 2025 and call for to give the explanation that the railway authorities have admitted the amount of the petitioner to the tune of rupees 73955557790. But the London advocate appearing for the railway authority failed to satisfy this court. This court finds that the respondent authorities have admitted the claim of the petitioner, the respondent authority within bracket Eastern Railway, have admitted the amount of rupees 739555577.90. And as such, it cannot be said that with regard to the said amount there is any dispute.
I have cited
Full stop. The petitioner, the respondent has relied upon unreported judgment in the case of Eyelid Foundation and another versus State of West Bengal and others. Another. Asked in WPA number 25102 of 2022, dated 17/11/2023, and submit that in the said judgment, the coordinate bench of this court has categorically held that which paragraph?
My lord, just paragraph I have quoted, my lord, 23 and last two paragraphs. Paragraph 23, my lord, 22, 23.
Held that the writ court may interfere in money claims or contractual cases or otherwise, although the contract is not statutory, subject to satisfaction of the. Yes.
Paragraph 9, my lord, several judgments have been quoted by.
Yes, which paragraph you are relying upon?
9, page 4.
Now, 9 is the judgment relied upon. Which main paragraph, which paragraph you are relied upon?
9. Then, my lord. (14). 13 and 14.
हाँ क्या बोला?
22, 23.
क्या बोला? Referred the wherein the on coordinate bench of this court held that there is nothing palpable on the face of the materials to indicate that there was any patent arbitrariness, unreasonableness or malafidis or existence of such like ground calling for such interference by this writ court. This court considered the judgment relied by the petitioner and found that the facts of the present case is distinguishable from the facts of the case relied by the petitioner.
There were disputed questions of fact in this.
In the judgment relied by the petitioner, there was a disputed question of fact. But in the present case, from the letter dated 10th of March 2025, this court find that the railway authorities have admitted the claim of the petitioner, but the amount was not paid to the petitioner because the amount was to be released by the garrison engineer. And thus, at this stage, the petitioner and at this stage, the respondents cannot say there is a disputed question of fact. Considering the above, the respondents are directed. What is the total claim? Where is the bill? Here, directed to release the amount of rupees 737,555,77,590 to the petitioner within a period of 4 weeks from the date of receipt of this order. Full stop. With regard to the any other claim and interest, the petitioner is at liberty to take appropriate steps in accordance with WPS disposal. Next.
What is it?
Very good.
My lord, I am for the petition.
Item 11.
Yes, lordship.
Yes.
I am for the petitioner.
Yes.
Matter relating to demolish the illegal unauthorized construction on the PWD road in the district of Howrah within the police station of Sagrail.
Who is making construction?
Some Christian making
You are
construction.
appearing for whom?
on the PWD road in front of.
You are appearing for?
Yes, I am for the petitioner. Here is my application service.
Petitioner এদিকে
আপনি cut.
That's why I'm asking.
Yes. Yes, I am for the petitioner. Paragraph 4, my lord, at page 5.
Paragraph 4, page 5 of the writ petition.
Lordship. That all on a sudden since from 23rd February 2026, some persons illegally and unlawfully with the help of local Gram Panchayat are making illegal and unauthorized construction on the said PWD road, that is at Satyen Bose Road, in front to the said property of the petitioner. Immediately thereafter, your petitioner submitted the written complaint to the authorities of the Public Works Department, Government of West Bengal, and also to the other respondent authorities, that is SDO, for taking necessary step and to stop the illegal unauthorized construction on the PWD road in front of the said property of the petitioner and to demolish the illegal unauthorized construction which have already been constructed on the PWD road in front of the said property of the petitioner. I have made representation. My lord, kindly consider the translation copy also there, page 36, 36A, 37 and 37B. This is also interpreted by the interpreting officer of the original site, Calcutta High Court. Page 36. I have made representation in Bengali.
Yes, who is appearing for the authority?
I am feeling the petition itself is very vague. What is the nature of construction? Who is making construction?
You are appearing for whom?
Similar circumstances.
Okay, consider the representation.
My lord, similar circumstances, Honorable Justice Devanshu Vasak also called for a report from the PWD authority, and thereafter, when report it is found that illegal construction was made, and that construction was demolished by the PWD authority.
To make an application before the.
Okay, I am disposing of this writ petition, directing the authority to consider your representation dated 24th of February.
Kindly direct the SDO then, my lord.
He raises allegations against the Panchayat authority also. That should
be
if the Panchayat authority is involved, he says it is being done with the help of the Panchayat.
Some miscreants, they are also involved with.
To whom you have made the representation?
SDO, my lord. Authority as well as SDO. They are the respondent number 3 and 4.
Only governor has not been notified.
Kindly consider Justice Devanshu was in correction in another writ petition. Let's kindly see. Execute respondent number 3 and 4. Let's kindly see. The respondent there is of him. Fortnight hence the call submitted. Lordship kindly call for the record from the SDO and the executive officer. Respondent 3 subdivision. Kindly consider cost title page 3. Call for the after holding a spot in
the grievance of the petition in the present date application that on 23rd of February 2026, some persons illegally and arbitrarily with the help of the local Gram Panchayat have started illegal and unauthorized construction on the PWD road in front of the property of the petitioner. When the petitioner has noticed with regard to the alleged illegal construction, the petitioner has made a detailed representation to the concerned authorities for taking appropriate steps for removal of the alleged encroachment over the PWD land and in front of the house of the petitioner. But in spite of receipt of the complaint filed by the petitioner, till date none of the authorities have taken any steps for removal of the illegal construction over the PWD road. Full stop. Landed counsel appearing for the state respondents submitted, though the petitioner has made a bold allegation in paragraph 4 of the writ application, but has not mentioned who has made the said construction in connivance with the Gram Panchayat. And he has made the complaint to all authorities, not to one specific authority. And as such, it is not possible for the authorities for disposing of the representation submitted by the petitioner. Consider the submission made by the counsel for the respective parties. This court find that the grievance of the petitioner that some persons in connivance with the Gram Panchayat has made a illegal construction over the PWD road, and the petitioner has made complaint, but that has not been disposed of. In view of the above, the writ petition is disposed of by directing.
I direct the district magistrate.
The authority to demolish the illegal unauthorized construction. Respondent number 4.
By directing the executive engineer PWD department to demarcate the land.
Lordship.
Demarcate the land in question where the alleged construction is made. If the executive engineer found that any persons have made any illegal construction over the public road, PWD road, the executive engineer immediately submit the report. Disposed of the writ petition by directing the executive engineer to demarcate the said plot where the alleged made within a period of 1 week from the date of receipt of this order. And if the executive engineer found that any illegal construction has been made on the PWD road or the government land, immediately within a week thereafter, the executive engineers will submit the report to the subdivisional officer Hora, to the district magistrate Hora. And on receipt of the report of the district magistrate, the district magistrate shall take appropriate steps for demolition of the illegal construction and eviction of the unauthorized occupation over the PWD land or the government land in question within a period of 2 weeks thereafter.
I wanted to include the district magistrate because there is an allegation.
Yes,
in the Panchayat.
That's how you
Appropriate.
SDO also.
They will have to move in.
Though the petitioner has also made the subdivisional officer as party and made a complaint to the subdivisional officer, but this court is not intending to pass any order directing the subdivisional officer and directed the district magistrate to consider the same, because there is an allegation against the panchayat for illegal construction over the PWD. If the district executive magistrate and the district magistrate shall also issue notice to the petitioner for his personal hearing at the time of demarcation and passing application. Next, affidavit service filed by
State, my lord, may I file a report?
I'm for the petitioner, my lord.
It is your safety.
Matter relates to my lord. I had challenged the my lord divorce notice issued by the my lord Muslim marriage.
Divorce notice?
Yes, my lord. First divorce notice. My lord, without jurisdiction, he sent the notice because my lord, the Emmanuel Kaji actually he is the resident of my lord district of Durham, and he got the my lord license from Postim Bordom Asansol. For whom he sent the notice, he received Golsi police station Postim Bordom. My lord, there is in the my lord, government circular. Each and every police station has a one man Kaji. He cannot cross jurisdiction. This is the main issue, my lord. The person against whom the notice has been sent, district Bankura, Patosai Thana police station, district Bankura. And my lord, his wife, from Golsi, Postim Board, Golsi.
Marriage solemnized.
Marriage Patosai, my lord. Patosai in the district of Bankura.
And where they are residing?
They reside in the Pathasar, and ladies, she generally she reside in Jharkhand. She is private service holder. Kindly see, my lord, paragraph 6 of my admission, and I have stated.
Notice.
Notice, my lord,
Page 30.
page 30, my lord, answer P2, my lord.
And my lord, subject to correction, he has not made a complaint before the authorities.
Who?
The petitioner. He is asking relief. My lord, before your lordship, where state is also a respondent. No representation that the Qadi has no power or the moment and manner
District state Purva Bardhan is the authority, my lord. Question number 3, my lord.
representation. We don't find any representation.
I challenge them, my lord. No, I challenge them, my lord. No representation required, my lord. District state, my lord, Purva Bardhan is my party, my lord, here. And there's no two also, my lord. The Inspector General of Police Registration and Commissioner Sam Devan, my lord.
Under which provision this notice is issued?
Muslim, my lord.
Under which provision the marriage officer has issued the notice of the divorce?
Well, so far notice is concerned, no provision is
then
yes, but it comes squarely. So, my lord, if your lordship kindly takes our report, that's come, my lord, we have annexed the particular act. That is the Bengal Mohammedan Marriage and Divorce Registration Act.
Correct.
1876. Now, your lordship kindly comes to section 3.
2.
That is page, yes, 226.
Section?
Section 3, man, of the act. May I place, my lord? It shall be lawful for the state government to grant a license to any person being a Mohammedan, authorizing him to register Mohammedan marriages and divorces which have been effected within certain specified limits on application being made to him for such registration. And in like manner, it shall be lawful for the state government to revoke or suspend such license.
Correct.
Now, pursuant to that, my lord, let him file a representation before the authorities concerned. Then, my lord, the authorities will concern. So far,
no, that's correct. That's correct.
Yes.
But if any person being a Mohammedan, authorize him to register the Mohammedan marriage and divorces,
which have been affected,
within the certain
limits.
Yes. So where that's why I'm asking where the marriage was affected.
Yes.
Where and where both the parties resides.
Both the parties, now at present, my lord, the husband reside in the district of Bankura, and my lord, the wife residing in the Golsi police station, that is posting Bordhaman, district posting Bordhaman. And now the Jharkhand, my lord, she is serving a private.
Yes, respect what tells from your lordship that has not particularly mentioned in the writ petition, page 3, paragraph 2 of the writ petition. My learned friend has mentioned that your petitioner states that he got married with Sarika Sabna on 1st July 24 as per Islamic law, and it has been registered before MMR and Qazi.
Yeah.
Bardhaman. Purva Bardhaman is a big district. Now, in which place not mentioned on the same day, it is stated that both of them enjoying peaceful.
Where is the Nikanama?
The Nikanama don't we have, my lord, that is with the No, my lord, Nikanama is with the my lord, woman's side, my lord. It is casting the father of the my lord, my wife, my lord.
How many years the marriage was which year the marriage was solemnized? 2024.
Yes, my lord.
You are not have you are not
I have not got the marriage certificate, my lord. The marriage was solemnized, that is correct, my lord. That's why this is the notice.
With whom? Who solemnized the marriage?
The marriage is
the registered marriage.
Yes, my lord.
So that will be a certificate.
That is yes, ma'am. That is Golsi. That is I went there. I got the married to Sarika Samnam. It's the system, my lord. The women residing in the Golsi police stations.
That's correct. I know.
And another marriage cannot come here. Cannot come there.
You have to go and you have to accept the Nikanama, and it has been. But who is the marriage registrar? Which area?
That is a Golsi police station, my lord. Golsi police station.
So it is not in the Paschim Bardhaman. It is not under the Paschim Bardhaman.
No, it is my lord.
It is a Purva Madhur.
Yes, my lord.
So whether the after the marriage, the MMR has given this marriage certificate.
Certificate, my lord, it is in the custody of the father of the my lord, my wife, my lord.
So you have to prove the court cannot call all the things, sir.
My lord, marriage, my was so there is a dispute regarding marriage, my lord. There is a dispute.
See, for getting the divorce, for filing an application for divorce, what are the things is required, you know?
Yes, my lord, that is.
What? Tell me.
First, my lord, marriage certificate, other.
Nothing. No.
Then, my lord, grounds of divorce. Actually, I have.
Divorce of marriage, last resident. Correct. These are the two things. That's why I'm asking. Where the marriage was solemnized and where they last resided. If the wife and husband resided lastly together at Paschim Bardhaman, she had a jurisdiction to file an application before the MMR. If the marriage was solemnized, there have a cause of action. Otherwise, nothing.
If your lordship kindly comes to page.
Where the marriage consummated. You are not having any file. How many? 4 paragraph application, writ petition drafted.
And no representative. Page 12, if your lordship kindly comes, man, that.
Can allow me to file this
Invitation card.
Is the invitation card.
Yeah.
After that, there are 2 documents. There will be Nikanama by the Qazi, by the what you said, the Masjid committee.
Yes.
There will be a certificate from the Masjid committee who has performed the Nikanama. Then there are after the certificate of the MMR.
Yes.
There are 2.
And so far the.
That. So that is called a Nikanama.
Yes.
Which was performed by the Qazi.
Yes.
And then thereafter the MMR will issue the certificate as the marriage officer.
I go down to your lordship.
You do one thing. You withdraw this,
Yes.
go and file appropriate application before this
Authority.
Muslim marriage register,
Yes.
taking the ground of jurisdiction, whatever it is. If it is not considered, then you
Then I have to file the district.
appeal is with regard to the any order is passed. If you are telling, that's why if this officer is not having jurisdiction, then your writ petition is maintainable. So you have to prove.
Kindly see, my lord, even in kindly see page 14, the envelope cover, my lord. The Muslim marriage Kazi, my lord, village and post office, Godha PS, Ilambada district, Birbhum. He is not also
Is it to you?
No. The marriage register from government West Bengal Muslim marriage Kazi, kindly see page answer P3, page 14.
Page
My lord, the
14.
marriage register residing in the Birbhum. He got, my lord.
No, but the page 13, can you see the page 13? Muslim marriage registrar and Qazi is the new township, Durgapur, Paschim Bardhaman.
Yes.
That is, my lord, new township, Durgapur police station, my lord, not from the Golsi police station. My wife.
So that's why
My wife is the under the Golsi police station, my lord.
you have to prove.
The kindly leave maybe get to 5 minutes happening.
And counsel for the petitioner press for time to file supplementary affidavit by disclosing the document according cases adjourned. Petitioner given liberty to file supplementary affidavit within a period of 1 week from date after serving the copy to and counsel for the respondent. Full stop. Let the matter appear on 25th August.
And a report has been filed, madam. Report has been filed by.
Report filed by the state authority. Be kept with the report.
Grateful to lordship.
Number 13.
Yes.
Meeting, my lord, I am submitting the report, my lord.
What report?
Meeting, my lord, 77 meeting is withheld by the Department of Home, my lord.
You have that guidelines. You have procured the guidelines. There is a guidelines.
Lordship.
The authority cannot keep the.
Lordship, I have got few recent judgments also, similar matter, how it is being postponed by them every time. These are contempt application.
No, there is I have passed an order, but
Lordship.
there is a guidelines.
Lordship. And also, Lordship, I would highlight the section 102 of the West Bengal Correctional Service Act 1992, Lordship. They are just merely sitting tight, Lordship.
Correct, madam. I am telling you, you persons are not doing the homework. On the last occasion, I also told that there is a guidelines of the national something or
National Human Rights Commission.
no, not National
Welcome.
Human Rights Commission. There is a guidelines. In the guidelines, there is a scheme has been framed how the authority has to decide with regard to the if the recommendation has been made, what is the period it has to be sent to the government and what is the period the government has to decide. I have delivered one order judgment, but I could not remembering. Just 6 months before I have delivered one judgment. That you bring, I will direct that. Can I call your authorities here? This is the way your authorities are when the meeting was conducted.
My lord, problem is that from the
I don't want the problem when the meeting was conducted. Call the GP. This is the way to give the answer to the court. I don't know. What is the standard of the government of West Bengal of the state authority? This is a standard. I don't know. On appearing for the state. When the meeting was held, I don't know. When the minutes of the meeting was sent to the state.
The date has not been fixed yet because the chairperson is the Secretary Department of Home, not the jail authority. Problem is that.
Since when? Last meeting, when the last meeting was conducted?
Conducted on notification is from 11/6/2026, my lord.
What notice? What notification? What notification?
Regarding 40 live convicts.
Last meeting, 76, when it was conducted?
21.
2021. There have been no meeting.
Lordship, there has been meetings, Lordship.
Yes.
There has been
You have
76.
no idea.
Lordship,
You have no idea.
76 meeting was held.
Madam, unless and until you will not sit with the authority, it is not, you cannot defend the state authority, I am telling you. Only because of the 3 paper report, it is very difficult.
Actually, there is no instruction regarding 76 meeting of the state.
Lordship, your last order reflects that the counsel for the petitioner fixed on June 21st, 2026, Lordship.
When?
Lordship, there was an order that was given by your Lordship on 22nd/06/2026, Lordship, the last order.
Correct.
Yes, Lordship. There was a review meeting fixed on June 21st,
Who is the
2026.
competent authority?
The Department of Home.
The Judicial Department, Correctional Department, Lordship, Home Department. They are all.
The person of the SSRB committee is the Home Department. The Secretary Department of Home.
This court find that the advocate appearing for the state is not able to satisfy this court. Accordingly, the Principal Secretary Correctional Home is directed to appear before this court with the report. When the last state sentence review committee board was held and when the next review board meeting is to be conducted. Let the matter appear on 13th August at 10:30 for appearance of the secretary, Principal Secretary, Principal Secretary to Government of India, Judicial Department. No, Judicial Department.
Lordship, affidavit of service, Lordship.
Hello, the instant read to this on 15 July, the matter was came up before your lordship in connection with the consideration of annexure P6 and P8. P6 and P8 and for giving effect of the order by the HIT and now KMDA at present. Respondent number 2 and 3. My lord, what happened? Thereafter, 2 title suit was
Just a minute. You can have. कौन है पान खा के थूका इसमें हाँ क्या है पान खा के कोई थूका है खा रहा था फाइन फिर ये पान खा के कौन थूका इस तरह में तुम साइन नहीं किया होगा उस तरह तुम लोग प्रिंट नहीं निकाला होगा Yes, who is for the state? Yes, what is the prayer?
My lord, prayer for consideration of the, my lord, execution of the order. Please.
Execution of the order passed by?
Passed by the respondent number 2.
Where is the order?
My lord, kindly see page 29, annexure P6 and P8.
Page 29.
Yes.
In order to rehabilitate this shopkeeper affected 2012.
Yes, my lord.
But
ultimately, the last
the constructor shop room so and so, order will be allotted to the shopkeepers for the purpose of rehabilitation of 90. Just a minute. Page 29 is this is of 12th April 2012. What is your name?
Pipasa Hotel. My lord, Alok Chandra Devnath.
Alok Chandra Devnath.
Alok Devnath and Tapun Guha Chaudhary. Joint partner.
Alok and Tapan Guha Chaudhary.
Yes.
Pipasa Hotel. So G81112. So 12,91,690. Have you deposited?
Yes, my lord.
Where is that?
My lord, that is page my lord, 32. Clearly written, my lord, right and 14 lakhs 42,000. My lord, supplementary payment, another payment was requested to pay in case for the case of staircase and
yes, yes.
And accordingly, my lord, the entire amount has been paid. Kindly see the annexure P8 for a moment. If deed will be registered, that was a part of the obligation of the statutory authority, my lord.
With reference to elections, member number so and so, I am directed to inform you that HIT authority. What is HIT authority? Hora Improvement Trust.
Yes,
has no objection if the bank authority allow the loan to you at their own discretion. Moreover, the final payment of the leasehold property will be registered following the legal formality. Yes. Then
my lord, in this subsequently, my lord, 2 suits was filed. That is in connection with the VAT. So that we cannot make a business, run the business. The VAT was constructed.
Who filed the suit?
Filed.
Who filed the suit?
Petitioner has filed it. It is the corporation. It is the corporation regarding VAT. And to
regarding
VAT. Garbage bag. Yes. My lord, thereafter, my lord, another suit is that is related with the godown. Godown has been temporarily created by the authority called KMD, that is KMHIT. And that 2 suits are not related. 2 suits are not related with the execution of the order and upon which the entire payment has been made. Now the
what is the prayer in the suit?
Prayer in the suit.
What is the prayer in the suit?
Kindly see page 32.
Permanent injunction, declaration that you have. Then
connection with the VAT, my lord.
No, kindly come to the page 38, sir.
Yes, my lord,
kindly come to the page 38, prayer I.
Not to disturb because so that business can be run. My lord, kindly see para 3, CL3. Permanent injunction restraining the dependent number 2, including their main and agent associates from creating any obstruction in the matter of free access at the A and B schedule suit property by constructing C schedule proposed that.
Yes, nobody is appearing the state.
Yes, my lord. The last location you are.
Just a minute. See the last order. Then you persons will say that this court is telling this. See the last order. Who has appeared? Just she was here. When the matter was called, she left. So then I will call all the authorities in all matters. What apologies? This is a way of the government advocates to appear in the court. You want all the in all cases the authority has to come here. When I call the GP, he's telling that henceforth I will see. I will call the AAG, I will see. That's all. And one statue has been put here. July 15, July, she has taken time. For what? This is very unfortunate affairs on behalf of the state authority. In spite of taking time, they are not bringing the report before this court. Accordingly, today when the matter is called, none appears on behalf of the state. This court find that on 15th of July 2026, Mrs. Sudeepa Banerjee had appeared along with Manisha Paswan, and on her pair the case was adjourned. Today when the matter is called, she was in the court, but when the matter is called, she left the court premises. Accordingly, taking into consideration the act of the government panel advocate, the case is adjourned with the cost of rupees 1 lakh. The state authority, the director, to pay rupees 1 lakh to the High Court Legal Service Authority within a week from date. Please the matter appear on 18th of August 2026. Next. Call that.
My lord, apart from the date of representation, date of the also the representation, my lord.
Well, next one.
Trying to go deep, not this may have a severe ramification. But I am a stevedore in respect of the Holdia Dog Complex under Shama Prasad Mukherjee Port. Now, I'm not, in the name of suspension, I have been actually revoked without giving an opportunity of show cause. That's inbuilt in the regulations. And the nature of suspension is such that it extends beyond the term of my license. Number 3, and most interestingly, it relies upon an instruction by an investigating officer. But how could the port know about the investigating officer's report as a matter of statement when the report has not been filed before the magistrate? Is a mystery. But the allegation is, on a particular day, the hired dumper was found to be carrying certain metallurgical coke. And it was found to be leaving the premises of the port with some remnants therein, when it was intercepted by the CISF. I am a stevedore, I have hired the vehicle through another transporter. There are 500 workers working under me at the port. And not only this, the director of the stevedoring company was put to jail. He was made to be arrested. The license suspended or revoked. I don't know what the concept is about.
What is the offense?
But that dumper was found to be going out of the gate with certain remnants of metallurgical coke. Alleged theft at the most. A vehicle offense. But travel under the Motor Vehicles Act, read with the BNSS now. Police report has not been given. Most interesting, please look at the order. But I can say that on the ground of non-compliance of the principles of natural justice, which is contained in the regulations, the matter can be set aside. Please come to the impugned order at page 48. But the caption is temporary suspension of stevedoring and shore handling license issued in favor of 5-star. It has been reported by Orissa Metallics Private Limited, a Rashmi Group company, that on 14 July 2026, a serious incident involved an attempted theft of cargo and occurred during the intraport transportation of metallurgical coke discharged from vessel number so and so at berth number 14. A vehicle bearing registration number WV59C, that's the hired vehicle, was engaged by their handling agent, Mrs. 5-Star Logistics Private Limited, for transportation of cargo from berth number 14 to storage plot at L2. The vehicle was duly loaded with met coke at the berth and proceeded to the plot for unloading. However, it is further reported that upon arrival at the plot, the driver of the said vehicle deliberately unloaded only a part of the cargo and retained approximately 20 metric tons of met coke on the vehicle. So, the direct allegation is on the driver. And exited the plot in presence of supervisor of Mrs. 5-Star Logistics Private Limited, that's the writ petitioner. The said vehicle along with a portion of the cargo was subsequently intercepted by CISA personnel while trying to exit from the dock gate. Thereafter, the vehicle along with the residual cargo and its personnel was handed over to IC Haldia Port Police Station on the same day by CISA. Subsequently, based on the prima facie facts, the investigating officer of Haldia Police Station informed Haldia Dock Complex that the above facts disclose a prima facie case of criminal breach of trust and criminal conspiracy. Not alarming for a citizen of the state. But where is this leading to? Involving the unauthorized removal and attempted transportation of port cargo. Hence, a complaint has been lodged for taking necessary legal action against the accused persons in accordance with law. In view of the alleged attempt of theft or pilferage of imported cargo from the dock premises of HDC, the stevedoring and shore handling license issued to Messrs. 5-Star, bearing license number so and so, valid up to 15th of November 2026. Please take note of this date. Is hereby placed under suspension under Regulation 13 L and M of the Kolkata Port Trust Regulations 2020 for a period of 6 months with immediate effect from 20th July 2026. But it explains that it extends the date, it goes beyond the date. Not suspension is interim, revocation is final, that we understand in common parlance. During the period of suspension, you shall not undertake any stevedoring or shore handling operations within the jurisdiction of Shama Prasad Mukherjee Port. You are also directed not to accept any fresh assignments until the suspension is revoked.
Yes.
The action is taken in accordance with the relevant provisions issued with the approval of the competent authorities. Not each and every sentence that we read inherits or not exact.
Where is the regulation?
No, this is annexed at page 51.
Relevant page 57.
They were invoked with 13 L and M.
Yes.
Relevant
Please come to note 57. No, page 56 first, not the section heading or the regulation heading. Regulation 13 is suspension and cancellation of license.
Yes.
1. The chairman may review the performance of the agents every month, and in case he deems it necessary, he may by an order in writing and for reasons to be recorded suspend or cancel the license issued to him on any of the following grounds, namely L and M have been employed. L is has indulged in illegal or corrupt practices. M has been guilty of misconduct which in the opinion of the board warrants cancellation or suspension of license. Similar, there has to be an application of mind by the board of trustees. Insofar as M is concerned, so far as L is concerned, there has to be an indulgement in illegal or corrupt practices. And how could the police the investigative officer of the state, he could inform this to the whole dock complex? It has not been reported to the magistrate through a charge sheet even.
Yes.
And please see the proviso, not the at page 57. Please see the proviso just after N. Provided that no such license shall be cancelled or suspended until the holder of the license has been given a reasonable opportunity for showing cause why his license should not be cancelled or suspended on such ground. So not L requires a finding that there is an indulging in illegal or corrupt practices, and M primarily requires formation of opinion by the board of trustees before the chairman can take an action.
Yes. Who is appearing you?
Yes, Malad.
Yes.
The Lordship Malad by the supplementary. Lordship
Oh, no, this is the copy of the license. No, that was same document, but not the period was.
Yes.
Page.
Page
8.
Page 8. Yes.
The stevedoring and shore handling agent as well as its staff, worker, engaged for undertaking civilian and shore handling operation over incidental there to ensure the compliance of the provision of the job. Malad, here Malad, he is saying that he is a driver. I do not know who he is. He is a driver, third party. He has to undertake the stevedoring.
Correct.
Now that I will come. I beg you, but my language will come on. Malad, I have not issued a permanent suspension order. There is no provision admitted. There is no provision under the rules for temporary suspension. Here, a person caught red-handed. Yes, that is the complaint made by our client to the authorities. Then when the police are investigating, and thereafter he was arrested.
The manipulator was arrested, the concerned two persons were arrested, you are arrested. So, my lord, even if my lord, a person has been suspended, I will issue a for permanent suspension. I will issue. I have not permanently suspended. Temporarily, that was the word has been used as a temporary suspension.
What is the
So, you
value?
have to
What is the value? What was the valid date of the license?
license is 15 November, it will be issued.
Just a minute. What was the
From the date
what was the valid date of the license?
15 November.
15 November. When the license was cancelled, that suspended. What is the date of the suspension?
20th July. But that day he can renew.
What is the date of suspension, sir?
15 November. my lord.
15 November. Suspension.
20th July, 20th July.
20th July. If 20th July we calculated to 6 months, what will be the date?
January.
What would be the date?
19th January.
So from there only it reveals that you have not applied your mind.
Well, that is applied, that is.
Record an order.
No, Lordship kindly appreciate. It has to off premise. If this thing will happen. So,
Many things happen in the dock premises. I know what is happening in the dock premises. You are not able to send.
Lordship, I kindly see that. Once Lordship kindly see that police report. Now, like kindly see one police report, my lord, and the complaint. Then your Lordship pass whatever the. BSCS number 94 dated Saturday, 316 3 61 2 3 5 DX.
Theft, 379, theft.
But in the moment, complainant is my lord Odisha Metallic Private Limited. He is one of the the petitioner is the clearing and forwarding agent of the Odisha Metal Private Limited. Complainant is Odisha Metallic, my lord.
They have said.
Page 48. Yes, page 48. I have it has been reported by Odisha Intelligence Private Limited. Page 48.
CIS.
That is the MP order, first paragraph. And so that on serious incident involving an attempt. Yes, the petitioner hearing. There is a person. Then, my lord, what is the what they were inquired in the matter, your lordship kindly the or here. That your lordship kindly report. Yes. I can take steps for
30.
My lordship kindly once your lordship kindly see the report of the police. Same thing is there. He cannot explain why it has been done. That is a preliminary inquiry. Preliminary inquiry.
My lord. But I was only worried about that particular sentence made in that suspension order. How could the investigating officer report to court?
Yes, your lordship, there is the family experience of the a person has been paid by the law and it's not really you were suspended. Character for another inquiry proceeding order. This person they are in custody,
Let us not delve into that issue, why he is in custody and whose interest is being subserved.
Court has an opinion, man. So, that my lord.
Component Stephen नहीं
As per the police report.
Grateful to you.
Will take appropriate steps after issuing. Malad, since affidavit has not been called for.
Sure. You'll.
With regard to only one indulgence with respect to item number 4. It was there in the list. He appeared online. I was there for the state. I indicated there was one mistake, but unfortunately I missed out. There is another change that has to be incorporated.
I am for the petitioner, my lord.
Page 19.
Page 19.
My lord, I am for the petition, my lord. Page 15, my lord. My lord, page 16, my lord. I'm grateful.
My lord, 130, I do not want to proceed, my lord. Grateful, my lord.
I am for the petitioner, my lord, page 38. I am for the 132. 130. I am for the petitioner, my lord, page 38.
Page 31.
132, Rashio, I am for the state. Page 42, my lord. I am for the petitioner.
135, page number 28. Lordship, 136, Lordship, petitioner is a second SLST candidate, Lordship, second state level selection test, Lordship, and impaneled candidate. Lordship, police verification is pending, Lordship. Lordship, petitioner is impaneled candidate, Lordship, state level. Petitioner is impaneled candidate. Lordship, state level selection test, Lordship. Class 11, 12. Police verification is pending, Lordship. Grateful, Lordship. Grateful, Lordship.
137, page 35, my lord.
My lord, daughter of the present petitioner is suffering from cancer, man. I have already annexed, man. For treatment, my lord, he has to go, my lord, 130. Mumbai, my lord. Every Mumbai, my lord. He has to go, my lord. Kindly give a short date, my lord.
One thirty.
My lord, I am the petitioner, page number 16. My lord, petitioner so only once on 6 years old. She cannot admission in the DPS school in Newtown under the 2026-2027. DPS Newtown, only one son, only 6 years old. But papers will be submitted. Papers.
Card verification করেন আপনারা।
My lord, my name has been deleted from the tribunal, my lord, and without hearing, my lord. My lord, kindly send back to the my lord, without hearing, they have no order passed, my lord, by the tribunal authorities. Just I have checked online and I. My lord.
Page 26, Lordship.
My lord, I am for the petitioner, page 26. 144, page 47. Page 47.
Page 53 to 56. And
26, page number 26.
Already disclosed.
149, my lord, 111 page number. This is the 110, my lord. 110.
Page 41.
151.
152. And for the petitioner lordship, page 31.
153.
And for the petitioner lordship, page 38.
154.
I am the petitioner, page 20.
155. Lordship, I am for the petitioner, page 12, Lordship. 156, I am for the petitioner, Lordship, page 15. 15. 157. 157, I am for the petitioner. My lord, petitioner daughter is a NEET aspirant candidate. My lord, she is not getting, my lord, the domicile certificate, my lord. My lord, the petitioner's daughter is a minor, and my lord, she is not getting due to her mother's name is deleted in from the electoral roll. $158, I am for the petitioner, my lord. My lord, two petitioners are there, two are the sisters, my lord. My lord, the petitioners number 1 participate in the, my lord, veterinary practitioner interview list specifically mentioned, my lord, which is page number 45, my lord. This specifically mentioned SIR deletions, updation of the SIR is required, my lord. Page number 45, my lord, I have annexed the, my lord, interview. All letter. Relevant is page number 45 is the interview call letter, and page number 46, my lord, documents required, my lord. Last, my lord, name in recent updated 46, my lord. This is a part of 45, my lord. Documents required, my lord, top, my lord. Last, my lord, last bullet, name in recent updated voter list from the SIR regulations, my lord, it is required. Petitioner number 1, and petitioner number 2 is registered nurse. I mean, she has applied for nursing officer recruitment. She also have, my lord, urgency. My lord, veterinary practitioner. My lord, interview is already conducted in 7th, my lord. Within 7 days, she is undertake that she will submit. Applied for nursing officer recruitment, common eligibility test. Code please. 159 from the petitioner, my lord. Petitioner applied for, my lord, NEET UG. Yes, my lord.
স্টেট তো যেমনি দেবে না উচ্চ উঠবে এবারে বেরিয়ে যাবে
Early in the morning, I mentioned the early in the morning, I mentioned the your lordship mentioned with at the time of rising, that one, my name is not recorded, early in the morning, I mentioned the your lordship, allow me.
same matter your lordship
Thank you. Well,
That's the
deeply grateful your lordship.
the seek your lordship's leave.
যে খারাপ দিয়ে আছে এই নামটা হবে কোন নামটা লিখে দেবো বলুন আমার একটাই ম্যাটার
Could I seek your lordship's leave? The norms, basically, but this is not the time for mentioning a norm. But this matters. Let's sense us matter. That I have that been that the teachers are being that may my matter be listed along with those matters. Oh, sorry.
I am not allowing the advocates, one advocate is appearing here, one advocate is appearing there, and both are making a submission. In that case, I am not allowing. On that day, for this reason, I am not disposed of the SIR matter. Your colleague is mentioning here, during mentioning, you are starting mentioning through the online. So you cannot take the benefit of the online. My document was appearing. Yes. I was appearing on the 7. There are two corrections. One correction has gone up. So I am mentioning. This matter, I can have 4 years.
order. The plot number is mentioned as
এটা হয়ে গেলে আমার হবে
the plot in paragraph 3, the plot number is mentioned as DB 18/9. After one solved it. But the notice for vacating was on another plot, your lordship, by virtue of another deed of execution, is mentioned in the notice for vacating. If your lordship kindly see this. In the third or fourth line, your lordship, it mentions that by a further the lordship, the prayer is it's in in prayer it has been mentioned that DK3 only. May I handle the incorporation of the deed of exchange and along with the plot which I am now in for. The correction is, the lordship, it will be plot number DK3 sector 2 Salt Lake, Kolkata. No, your lordship. What's the plot number? DK3. No plot number DK3. No. DK3, that is DK is the block essentially, but DK3, DK-3, -3, comma, sector 2. Yes, Salt Lake City, Kolkata 70009. No, your I'll explain your lordship. Your lordship, if your lordship kindly takes a look at the notice for vacating. Because July, you're coming after a month. When is that next date? After a month you can. Then only you realize. Yes, your lordship. And area? 7,191, that's it. Oh, measuring 30.133631. Your lordship, may I explain? That is the plot which was 133,631. Yes, your lordship. It is also mentioned in that notice for vacating. In the first paragraph only. The whole thing is different only because by the 7 lakh, Kolkata 7 lakh 91. And the other correction which has already gone in, the lease deed will be on 1991 and 2000. And your lordship. And only one more thing, your lordship, regarding that only. That plot came into our possession by virtue of the deed of exchange, which is also mentioned in the.
This is a matter, my lord, which is basically with respect to, my lord, challenging the elections of the medical council. Now, it's been going on, my lord, since 2022. The next election, my lord, is in next year in August. Your lordship's last election was, my lord, if your lordship sees, this is 15th of June. My lord wanted them to use, my lord, an affidavit, which probably, my lord,
If I go for the medical council, my lord, we are filing affidavit in opposition, my lord, from today. But may I serve the copy on that? I'm led by Mr. Sen, your lordship.
and then your lordship sees paragraph 7 of my lord's order, my lord, with respect to informing the state. We've also informed the state, and this is the email that we have, my lord, informing the state.
That's the order as well as the petition.
So now, my lord, kindly fixes a date where your lordship hears out the matter, my lord, once and for all. This is only with respect to, my lord, on the face of it, will show, my lord, that the election itself was wrongly held. My lord, the human who is supposed to, my lord, this was admitted long time back in 2022. There were directions for keeping, my lord, the files ready, or because on the face of it, my lord, we will show, my lord, that the person who was conducting the election did not have a right to conduct it.
We have taken
The registrar, my lord,
he did not have the powers because he had superannuated. And that, my lord, we had to come before this honorable court to get him, my lord, out of the council. Yes.
Well, it's may I just indicate.
This will be the short point. And the second point, my lord, which I will elaborate later, my lord, is with respect to the discrepancies. The special officer was appointed, all the ballots were, my lord, checked, and the special officer has given a report. On the face of it, your lordship will find out discrepancy.
Well, these points, my lord, in my respectful submission, my lord, perhaps cannot be pointed to. That apart, as per the last order, my lord, we are filing the affidavit in opposition in respect of petition. There is also direction in respect of WPA 2 on the petitioner, my lord, to use the affidavit. On one side, my lord, we are filing the opposition, my lord, perhaps reply from the side will be due.
My lord, lordship kindly fixes a date, where, my lord, I will take about 30 to 45 minutes of my lord's time, and that is it.
My lord, I'm sorry,
Not
the
beyond.
petition.
Because now what happens is, my lord, if this is not heard, then the next election comes in, my lord, within August.
This is fourth my W. Passport is found versus state of West Bengal. The pleading is not complete. I have filed in opposition to lordship.
23439 is complete. Everything. This will take 3 or 4 days to.
Well, the other.
Yeah, it's on record.
It is.
It's on record.
But other two writ petition in lordship, well, perhaps pleading is not complete. Well, in filing petitions, which is and 232.
This takes care of.
Well, I'm appearing to West Bengal Medical Council.
And my lord, this is the affidavit করে নিতে হবে। এরকম একটা কাগজ জজকে আমি তুলে দেবো, যে কাগজ নিয়ে এসেছি দেখ, সেটাও মানে তুমড়ে মুষড়ে করে নিয়ে চলে এসেছি। Lord, within এত সময় নিচ্ছে না, এক সপ্তাহ মধ্যে করে দেবো, কত লিখবে আর। তো অগস্ট মাসে দেখো, if it comments to your lordship. I'm just trying to be a little bit greedy, nothing beyond that. But if it's possible, my lord, because kindly appreciates, this is with respect to the every doctor, my lord, in the state of West Bengal. This is not with respect to, my lord, 1 or 2. Every doctor, my lord, what happens is, if your lordship sees the rules, the postal ballot goes to, my lord, somebody in Murshidabad. The person who sends it, they don't even know if it has reached that doctor in Murshidabad. And then, my lord, it's found on the roads. All those bulk of those ballot papers are there on the roads. Somebody sticked here, somebody has sticked there. There is a double cross where they think that the vote is not coming to them. There's a double cross. All these have come up, Lord, in this. Down, ঠিক করে। Peter. ডেট চাইছি, আর করতে চাইছি না। Any Saturday also, I'm agreeable. Mr.
That Mr. Chatterjee is saying now, but after he goes out, he will never come on a Saturday. He'll introduce a resolution in the Bar Association.
I am not part at all, my lord. I will be before your lordship.
পুজোর পরে।
Very. So grateful.
One date.
No, দুটো।
One date.
দাদা। 45 minutes maximum. শেষ কথা।
সব affidavit complete হয়ে গেছে?
আমরা রিপ্লাই দিয়ে দেব।
And my lord, all whatever, my lord, pleadings are required, we may file it, my lord, within that period of time and serve it on the other side. It also directs, my lord, the state to appear. We've given them, I am not handing it over because I don't want your lordship to have a piece
Yes,
of
I
paper.
think the state should appear
The
now.
state should also appear. We have informed them. Everything has been done. We'll use an affidavit and give it to your lordship. Affidavit করে দেবে। So grateful, my lord, extremely grateful.
Number 15.
I'm under the private respondent. I need a hard copy, though I have gone through the petition through my soft copies.
I am for the petitioner, my lord. This is my affidavit of service, my lord. My lord, the issue is that, my lord, the property is belongs to the ancestor of the petitioners, but there is pending a title suit. During this, injunction order has been issued in favor of my client. But the private respondent number 5 and 6, my lord, they have sold to this respondent number 6 and 7 and 8, my lord. During and after that, they are not allowing us to enter into that temple which was belonged to the petitioner's father. My lord, the annual, my lord, একটু রিটটা খোলো, এটা আছে। আরে 10 নম্বর পেজে, পেজ নাম্বার 10 খোলো না, গুলো দেখো। Yes, my lord. Yes, দেখো।
Registration of a fire. There is a suppression of material fact, my lord, injunction was vacated. And this, I have the order with.
Paul said, because I have checked with the lower court, they have no appeared at all, my lord.
My lord, on my lord 23/6/2026 injunction. Yes, yes, yes.
Number 15 ছিল, বলো।
পরে পকেটে রেখে দিই, পকেটে রেখে তোমার জন্য বলেছি, ঠিক আছে, ওটা
করে দেয় এটা।
On earlier occasion, your lordships take up this matter, but on 10th July 2026, and your lordships directed the state authorities to take instructions. My lord, petitioner seeks for, my lord, legal heirship certificate, my lord, as she is the daughter of, my lord, kindly see the impugned, my lord, rejection order, which has been made by the district magistrate, is at page 17, my lord. My lord, they have issued a legal heirship certificate, my lord, in respect of my mother only. My lord, my name has been excluded
My lord, I am the daughter, married daughter. Married daughter of my lord, of my deceased father Santosh Datta. My lord. Mother. My lord, I am the only daughter. My lord. My lord, the name, my lord, last line, kindly see the last line of the my lord, rejection. The aforesaid legal heir of the deceased is entitled to get area of pension, nomination rules 1986, published under the Finance Department, Government of West Bengal, by notification number such and such, with read with such and such. It is revealed that the deceased left behind his married daughter, namely Nomnara Datta, petitioner before your lordship, who is not the relative of the family of the deceased as per relevant rules. The wife of the deceased, that is widow, is entitled to receive the benefit of family pension. Well, this was issued with an assumption that I am claiming the family pension. Well, but I all along, I have prayed that I have made an application for getting the compassionate appointment of my deceased fathers, who have died in harness.
Everything is ready.
That's why your lordship on the last occasion directed the state respondents as to how this legal issue certificate has been issued.
Planet AGP Manju Agarwal is appearing, my lord. And it kindly comes to the legal heirship certificate, my lord. There is only one legal heir, is Apurna Datta, my lord. There is no name of the petitioner. Read petition, my lord, page 17. Department. No, my lord, definitely she is a legal heir. Well, that AGP is very good. Hmm? No, it cannot be. Yes. No, my lord, it cannot be. It cannot be. It cannot be something which, my lord, I cannot also say. Yeah. But now we have to see.
My lord, I am not claiming family pension. I am land and land reforms department. But I have given the instances also. Other my lord districts, district magistrate has issued me, but legally actually kindly see the page 22. They have categorically issued the my lord legal heirship certificate with mentioning that the married daughter is there. Page 22. And I am praying for my lord revised legal heirship certificate.
Lordship, I will not stand in the something which is I cannot myself accept. But your lordship will not record my concession.
মেনুর দিতে হবে না মেনুটা শুধু মেনু ঠিক আছে may my lord sleep my junior is
নম্রতা দত্ত I am grateful to you. Bye. Grateful.
Lordship, in this matter, I am appealing on behalf of the petitioner. On the last occasion, there was a direction to file a supplementary affidavit. This is a case where both the petitioner has applied for IBF proceedings, but due to lack of age of one party, wife, husband is eligible, 52 years. Eligible. One of the party is eligible. Both are applying as a commissioning couple. Husband age is kindly come to page number 19 and 20 of the writ petition. Presently, husband age is 52 years. And wife has just crossed the age of 50 on 18th of June. After woman, for woman 50, woman for the wife is a 50.
And for husband is 55.
That's kindly come to 21G.
20.
ARTF 21G. তোমার কাছে আছে? দিয়ে দিন, দিয়ে দিন। Lordship, in section 21G, it is mentioned here husband age is 52. Lordship, kindly come to page number 19 and 20 of the writ petition. There is other both. Lordship, just now don't have, but kindly come to. Yes. Kindly come to page number 12 also. It is a certificate for registration. Page number 12. And so has 2014, since after few days of marriage. Yes. Just after few days of marriage. Lordship, thereafter, since 2014 treatment continuing, I have all relevant documents. Some of the documents has annexed with the writ petition. Subsequently, I have filed a supplementary affidavit, whereas continuation of the latest certificate, Lordship, kindly come to page 21 of the petition. Yes. At that time of filing of the instant application, she was 49. Thereafter, just on 18th June, she has crossed 50. Absolutely. 49 years, but as per the no, not completed. Continuing. 18/6/2026, she reached age of 50, not 51. 18 June 2026, she has reached
49 plus.
Lordship crossed 50 crossed 11 as on that 50 crossed. On 18th of May, she was 49. Subsequently, certificate of husband. Lordship, these containing both the petitioner's document, this is to certify that Mrs. and Mr. What?
Yes. Lordship is asking for fitness certificate of the husband.
No.25 cannot go.
Okay,
As per the age that they pass,
understood,
this court cannot extend the age.
understood,
Correct?
understood.
Now, the husband is within the age.
Eligible
When he goes to complete 55.
after 3 years. 2027. Like, as early as possible within 7 days. 2 weeks, 2 weeks.
Nineteen million, I am for respondent 1 to 3. Your Lordship had already decided on the interim relief. But I must tender an apology. I have not been able to file my affidavit in opposition.
Lordship, may I just indicate one thing? The work order has already been issued. The Lordship has, as an interim measure, because there was a recommendation by the Tender Evaluation Committee for dividing, by verifying the document from the issuing authority, the Tender Evaluation Committee recommended for my department. Your Lordship has granted stay on this. I have made specific complaint against the successful tenderer regarding his eligibility, as well as he has submitted forged document. That representation is yet to be decided. As on date, by filing affidavit, since the work order has been issued, if your Lordship, I have started. The person against whom I made the complaint, who is the respondent number 4, I have made specific complaint against him that he do not have the Provident Fund registration. I submitted the complaint along with the document. The complaint is appearing at page 145. As on date, simply I am beseeching your Lordship kindly direct the ESI authority to decide this representation within a certain period upon giving opportunity of hearing to all the parties. And if my complaint found to be justified, appropriate steps should be taken by the authority. Your Lordship, kindly come to page 148 and 149. These are the two documents issued by the Provident Fund organization in favor of this Patel Construction Company, who have now been given the work order. If your Lordship kindly consider page 148, the column number 6, ownership type, proprietary firm. As your Lordship kindly come to the next page. This is in respect of the same establishment, Patel Construction Company, serial number 6, partnership fund. Both these certificates are issued by the Employee Provident Fund organization. I made specific complaint to the ESI authorities that the person who has been selected as a successful bidder, he has submitted forged document. Till that, the issue has not been decided. And on the contrary, the document which I submitted, they inquired from the issuing authority, they certified these documents are genuine. In spite of that, Tender Evaluation Committee recommended for my department. As on that, since the work order has been issued, this particular Patel Construction Company, they are carrying with the work, with the blessings of the ESI authorities, overlooking my objection. Lordship, kindly direct the authority to consider my complaint, which is at page 145 and 146. Lordship, that your Lordship has stayed, because Lordship, kindly protect me to that aspect, because they are verified it. They have verified it from the issuing authority. I submitted 2 certificates from the State Fisheries Development Corporation and from Barrackpur Municipality. The ESI authority
On the face of the record, your lordship, the teacher said only that this recommendation was absolutely that because they have verified.
That's the intent. So that the final.
Good.
This code for the final finding, how the final finding. Considering the representative, this code cannot give any finding. This code cannot decide because of this thing.
That is exactly what I was praying for, Millard. I already made substantial arguments, so Lordship had recorded substantial arguments.
From our experience, we have seen by the time the affidavits come, the contract period will be over.
But this is the first time I'm coming before your Lordships. I am not in the habit of taking repeated time for affidavits. I'm grateful. I'm grateful.
What's the input order?
I'm grateful.
20, I am for the petitioner, my lord. The last occasion, my lord, on 21st July 2026, the matter was moved. On that occasion, my lord was pleased to direct the respondent bank to show the law whether the guarantor's property can be kept.
Sonioja is appearing. I am paying for short passover, my lord. Number 6, short passover. My lord, there is submissions. As per law, guarantor's liabilities, the liability of the surety. The liability of the surety is coextensive with that of the liability of the principal.
If suppose I am the security, and you have kept the document and the landed property linked. Correct. I am having loan for other my own purpose, and I have cleared my loan. Whether mine that property of your loan.
No objection has been given because he has been.
Whether he has given the writing, yes, this may be kept as a deed, then he will be out. Or you tell that yes, back law has said any property can be kept in deed, then I will.
There is an agreement with the guarantor also by the.
That's what I'm telling you. With provision, you can retain the guarantor's property which was not a property of the original loan.
There are some judgments and also law, my lord. Law also. Madam, Miss Sonioja will submit my as per instruction. I cannot make submission without.
I report to the business.
No, my lord, Miss. Only 10 minutes possible, my lord. Kindly granted. Then it is not today, my lord, for tomorrow. Then any day short day. Because as per instruction, I cannot submit, my lord, without.
Advocate is coming before this court. He's very busy lawyer. If you want to contest the court, then you have to either appear online or through the personal appearance.
That is going on in courtroom number 6, my lord, for that reason.
Kindly keep that matter. Come,
I was on like my lord. Yes, Lordship, my agreement provides in both the agreements, in the loan agreement with the petitioner as well as the loan agreement where the petitioner is the guarantor, my lord, that in case of any outstanding, any other loan, the bank can has right to withhold the NOC and the other documents. Here, no document has been withheld, my lord, only NOC. Now, kindly come. 171 of the Contract Act, my lord. Yes. Oh, yes, my lord.
So your agreement and the guarantor and the bank.
Yes, my lord. The copy.
Thank you. Always the new law.
My lord, the agreement provides so, my lord. Jayatri was agreement about that. The petitioner, yes. The loan which she obtained, my lord. The petitioner obtained, my lord. And yes, and there is another agreement which in which the petitioner. Your Lordship, Your Lordship, I have not withheld any property of the petitioner. Only NOC in respect of the petitioner present loan is that has been withheld because.
Hello? I
It
want to want NOC. NOC in respect of WAD agreement number WAD 00448E. My lord, kindly come to page 26. That is the letter of denial. Page 26. My lord, may I be permitted to read it out? Reply to your letter dated 30th January 2026 sent by in connection with you agreement having number WAD 00448E. And my lord, it has been denied. My lord, I am reading it out from the second paragraph. At the very outset, we would like to inform you that we are a financial institution dealing with a public money and provide financial assistance to different borrowers. It is pertinent to mention that your client had entered into another loan agreement, that is WAD 0048E, as a guarantor, where Mr. Imtiaz, son of such and such, and residing at such and such, was borrower. Your client had the same responsibility as a borrower towards timely payment and closer to full satisfaction of the bank of the loan account being such and such as per the terms and conditions mentioned therein. Further, the loan agreement are all linked marked as per the terms and conditions of the agreement. Hence, NOC will only be issued upon closure of the other loan accounts. My submission before your lordship that in respect of the my loan account, the entire payment has been cleared along with the all penal charges. NOC has been withheld only because the loan of one Mr. Imtiaz is going on. There is no default. There is no default of payment in respect of the loan account for Mr. Imtiaz Ahmed. My lord, my lord, the contention, my lord, in respect of my loan account, I have paid everything. I am seeking for NOC, my lord. Yes. Yes. In another loan. But that is the difference. That I am a guarantor. Being a guarantor, my lord, kindly allow me, being a guarantor, I will fulfill my all responsibility as a guarantor in respect of that account, which is in the name of Mr. Imtiaz. That is going on. There is no default. There is no default. But in respect of my loan account, the entire payment has been clear. But you are the guarantor, that will not be. Yes, my lord. What is my fault? There is no lacuna in part of both of the account. There is no dispute in respect of the both account. But why? I'm questioning myself, my lord. Why the bank has the right, obtained the right to?
May I make two submissions, my lord?
That is my right. I have my right. Yes.
As also
Is there any,
liability.
this I'm questioning myself. Is there any dispute, my lord? Yes, my lord. The Canara Bank or third bank, and you obviously 1 crore to it, and you are the defaulter. But another person. And you are a defaulter. And the Canara Bank has started the surface act. And here also, where are you are the guarantor, that is also defaulter. Where the bank will go. Another proceeding will be initiated against me, my lord. Another proceeding should come guarantor. What is the guarantor? What is the guarantor? But I am fulfilling my duty as a guarantor.
May I just have?
My lord, I am relying on judgment, my lord. My lord, what? My lord, I wanted to show you my judgment, my lord, passed by the Madras High Court. My lord, kindly consider, my lord. Without considering this judgment, my lord.
Hmm. Yes.
My lord, I am for the step. My lord, your lordship is aware of the statute. Statute is very clear. Now, point is, my lord, the statute, it specifies the age limit for a reason. It is a matter of fact, my lord. Beyond 55 years, the motility of sperm, because it is the union.
That one of the lady is the within area.
Very well, but then my lord comes to the report. I am not in the way, but my lord, the report speaks otherwise. Kindly takes up page 20, my lord.
Yes, that's right.
My lord, if they are fit, we are. I leave before your lordship, but since
Kindly come to the page 19. Kindly come to the page 19. Read the paragraph, not read slowly, not wide, loudly. Read one. Then kindly come to the page 21. Can you read? Then
36, page 36, 37.
what can be done? Your doctor is stating something and requesting something. Your doctor is stating something, paragraph 1, and paragraph 3 is requesting something. How the court will pass an order, how the doctor will do that?
Well,
if the court will pass an order, then in contrary to the paragraph 1 of the page 19, on the age limit is no, that's why I told you to read paragraph 1. You go to the doctor, examine the wife, and come with the first certificate. If you'll be able to get the certificate, come, you'll pass an order. Whatever it may be. I cannot suggest the doctor. Correct. Bring the first certificate. The certificates which you are disclosed, that is the contrary. Counsel for the petitioner press for time to obtain first certificate to ascertain whether the petitioner number 1 wife can go for the ART procedure or not. According petitioner given liberty to file supplementary affidavit within a period of within 10 days after serving the corporate and counsel for the state, release the matter on 26th August. 26th August. 26th August. Come. Good. Yes, call. बंद करो बस within 10 कर दो.
One last matter, very short.
Within 10 कर.
There was some urgency.
Which matter? 22.
Next one, 22. I promise you that I'll not take more than 4.
Who is for the other side? All the
My lord,
The lordship is so overcrowded with matters. But I'll straight away come to the.
Vice. MCA.
Shell companies. So that the present petition is one in the 331 and it directed the concerned stock exchanges to examine and file a report or take steps to ensure whether it is a shell company or not. Not the subject, the petitioner, it fell within the 331 group and within the 85 companies referred to Calcutta Stock Exchange. So Calcutta Stock Exchange told me give documents, give your documents, statement of accounts, all your transactions. So we did that. The entire exercise was undertaken and eventually, what CSC, the stock exchange does is that, they approve the fact that I am not a shell company and there was no adverse finding. So far as the report is concerned, my lord, if your lordship kindly takes a note of the forensic audit report at page 161.
Yes. 187 conclusion.
Yes, my lord.
Shell company has not been defined anywhere since. What is your name? What is the name of the company?
Well, Exim Finance.
Exim P and Unit.
EXIM, Exim Finance, which is the first matter.
Yes. So, where is that? Where is the order? Where is the report?
Then, my lord, based on the report filed by the forensic auditor, where there is no adverse finding in respect of the petitioner company, my lord, we requested.
Where from you got that there no adverse report?
No, my lord, if your lordship will take the report. My lord, if your lordship will see. Well, company wise they have given. If your lordship takes the report, give the relevant page.
Page 187, 187.
Well, if your lordship looks at page 1601, 10th of July 2023.
160.
Yes. 160.
Yes. Reference to forensic audit conducted in
Kindly take the second paragraph. Please note that members of the said committee, after detailed deliberation, resolved that you would be requested to approach MCA for removal of the name of your company from the list of suspected shell companies. Copy of the forensic audit is attached for your records. So I received this, then I write. So kindly see who do I receive it from? Kindly see this. CSE-India.com. So stock exchange gives me the report. On top, 10th July 2023, July 10, 23, 2:16 p.m. Towards the middle of the page, Prosenjit Datta.
Yes.
So Calcutta Stock Exchange forwards me this communication along with the report and tells me that kindly approach the Ministry of Corporate Affairs for removal from the suspected list of shell companies. So
no,
then,
no, 160.
Yes,
kindly come to the top.
Yes, my lord.
Forwarded suspected shell company from Maxim Finance.
So,
Finance.
This is the trail mail. I get it. So the mail which is at the bottom is the real mail.
Correct.
Then the mail on top is the forwarding mail.
Correct.
So if you will see, That's why there is kind attention such and such, sir. The one below is the original mail, which has come from Calcutta Stock Exchange to me.
Yes.
Then Calcutta Stock Exchange Chief Financial Officer, Prosenjit Dotto, writes to me saying that the committee after deliberation
Yes.
has come to a
So you go
conclusion.
to the MCA and
MCA, and based on the report, there is no adverse finding. So I go to MCA. Now, my lord, kindly come to my request to MCA, which is at page 193. I said that please, this is the report, kindly remove so that I become an active company. So no response, then I give a demand justice, which is at page 235. Then my lord, kindly see Ministry of Corporate Affairs, MCA portal. I have given the MCA, my lord, the master data, which is print dated 4th February 2026 at page 255. Your lordship will find I am an active company at page 255, just to show your lordship that I am still an active company. Even the MCA portal.
so you are there only.
No, I am active. But if you have a shell company, I have a shell existence. I am a shell company identified by SEBI. So this has to be done. I have to list of prospective shell company, the list of prospective shell company. That exercise have been undertaken. Now, my lord, kindly see despite the 2 requests and 3 requests made by us, no steps. Take steps in terms of the forwarding letter.
With the MCA.
My lord, I am MCA. So he is MCA. What is no?
22 in item 22, SEBI is answering this. We are not.
No, SEBI has
My
got
lord-
nothing to do with this.
My lord, I'm
CSC, Calcutta Stock Exchange has said, please approach MCA. MCA is my principal respondent.
Yes,
My lord,
madam.
my lord, I'm appearing for SEBI in item 22 to 25, 24. My lord, on the last date of hearing, your lordship had appreciated that since the list of suspected shell companies was authored by MCA, SEBI does not have any role in removal of the name of the petitioner company from the list.
That's why, who is the MCA?
Instruction study, proper instruction from the NP, but your lordship let us find a report, your lordship. Let us come to the.
Who is appearing for the MC? I am asking first. You are appearing. So what is the submission?
Upon instruction, I am submitting your lordship kindly. I will report your lordship regarding their.
No, see here the simpliciter.
The department take time to answer to your lordship. That is why I am asking to your lordship to give me the opportunity, your lordship.
So why this was on 16 July? 1 month has been passed.
Your lordship, we have sought for that. Order is required, your lordship, that.
What?
File a report.
For what?
Your lordship. File a short report. Let a short report, your lordship, that will clarify everything.
My lord, can I show your lordship a identical situation, another coordinate bench order?
Let they come.
No, my lord, this similar situation in respect of another shell company, where my lord, kindly, the allegation was that this is also a suspected shell company. So coordinate bench, my lord, kindly see the second last paragraph.
Yeah, that's why I wanted, but they want
report and do more.
Madam, here the only question they are asking for deletion of their name as a cell company.
And if they don't, then I have a fresh cause of action to come before your lordship. Again, she will not been able to understand the point. Your lordship, kindly dispose of the writ petition by similar order. MCA to deal with my representation and let them decide. If they say no,
How soon you will come?
Just try. 2 weeks.
No, 2 weeks, nothing, because you are on initially you are not appeared. Then this court has directed to again serve.
We were not aware that the matter has been listed at top, Your Lordship.
Then,
Copy affirmation.
and counsel for the MCA, press for time to file report. Accordingly, for the interest of justice, case is adjourned for a week. Let the matter appear on 13th of August and on 20th August 2026 within 5 matters.
Last August night on 16th of July, our name is reported 543. WPA 543.
পরেরটা তো same order.
Yes. Yes, cross.
Brother, 23 and 24 same, identical matters, but also 22, 23, 24, same order will be passed. Grateful.
The petitions are different.
Well, then, of course, the petitions will be different.
My lord, at the first morning, my lord, I mentioned interim order is still today.
Which matter?
My lord, item number 56, other side is here.
Item number 56.
Six, my
Record an order. Though the matter is listed as item number 56 of days list, but the matter could not be taken up for hearing due to paucity of time. According counsel for the petition, mention the matter and submit the interim order is still today. Consider the submission made by the counsel for the petition. The interim order is extended till 15th of September 2026 or until further order. Let the matter remain in the list.
Have your lordship's time?
Yes.
Item number 30 and 31 of your lordship, your lordship on the last occasion, I directed it to appear in the top 10 minutes. And I understand your lordship, this one of your client not mention the matter. I would be requested your lordship. Right urgency in the matter. As per my lord's convenience, lordship takes it up on any day.
Okay.
31.
Let me see. Okay.
Lordship, may I be permitted to mention item 39 of today's list? Lordship, my interim order is expiring tomorrow, Lordship.
Tomorrow?
Tomorrow, Lordship.
Mention tomorrow.
Lordship.
May I original side mentioning, my lord, item number 87, my lord. My lord, I have some, my lord, difficulties.
Yes, call the list.
Upgrade, my lord. Original side.
Item number 30, my lord, direction after the petition, but instead of petition, it will be secret department of home.
Let the judicial come. I will see.
Right. My lord, item number 87, my lord. Kindly, my lord, upgrade it, my lord.
Yes,
call
the list. Yes, original side, who is there?
My lord, this is my lord. This is my lord, proceeding, my lord. My lord, Thika controller, my lord, illegally, my lord, accepting rent from the, my lord, stranger person, my lord, despite of the KMC's order and also dismissal of.
Yes, who is the number one?
Lord, I appear for the petitioner. Lord, the last occasion, your lordship has directed us to seek instructions from the client from whether we would like to proceed. Lord, the client has instructed us that he would like to file a suit and accordingly instructed us to withdraw the petition.
Counsel for the petitioner has handed over a written instruction of the petitioner and submit that the petitioner the petition is not intending to proceed with the present writ application and he will take appropriate steps to file a civil suit and he prays for withdrawal of the present date application. Consider the submission made by the counsel for the petition and the written communication dated 11th August 2026. WPO number 104 of 2026 is dismissed as withdrawn. Liberty to the petitioner to take appropriate step before the appropriate forum.
Item number 2, my lord, I beg to appear for the writ petitioner, my lord. But I am a company, my lord, manufacturing cooling towers and allied equipments. Now, my lord, this writ petition is, my lord, being heard for the first time. My lord, on my instance, I have filed an IN and give a short background. But I have taken a fire insurance policy from the respondent company, New India Assurance. Now, there was a fire in my factory in Ghaziabad in May 2024. Now, my lord, I make an insurance claim for the fire incident. I have a policy which, my lord, allows me to claim for reinstatement value of the property. Now, if the property gets destroyed, then I reinstate it, or the insurance company reinstates it and pays me for the entire value. Now, my lord, the reinstatement took some time. I sought for extension of time because, my lord, the policy says I have to reinstate within 1 year. I sought for extension. Now, my lord, without any reason, without giving any explanation, the insurance company rejects my request for extension of time. After the extension of time, that 12-month period has already expired. I pay for extension of time in November 2024. In December 2025, the request is rejected. So what I've come before Lordship,
What is the request?
my request for extension of reinstatement period. Under the policy, I have to reinstate the damage within 1 year, 12 months. Now, I was taking time because I had to relocate the premises. I had sought permission and I was relocating the premises. That was taking longer than 12 months. Requested for additional time to complete the reinstatement. The reinstatement has been completed in November 2025. But even after the completion of reinstatement in December 2025, the insurance company rejects my request for the extension of period. And because of that rejection of extension, my policy now is valued as per indemnity basis, which means that the depreciated value is given to me. My claim is almost around 50 crore rupees. I am ultimately now, due to the pendency of the petition, in July of 2026, my claim has been assessed by the company at 5 crore 69 lakh rupees. Now, I filed this IA for the simple limited purpose that I be permitted to receive that amount which they have assessed without prejudice to my rights and contentions in writ petition. But in the writ petition, I have sought for the quashing of that rejection of my request for extension. That is my prayer in the writ petition. Now, because they have assessed my value in the meantime, I am praying for liberty to withdraw that amount which they have assessed without prejudice to my contention in the writ petition. That's my limited prayer, my lord, before your lordships today.
You don't know.
There's an IA which I have served and I have
You're
a.
not aware, but anyway, two things are very important.
But I have a affidavit
The
service.
writ petition may not be maintainable anymore. Because their complaint was that there was no survey report about report which was done. Now the report has been done, good, bad, whatever it is, the insurance company resisted for that 5 crore
69
and 69 lakhs, which we activated. It's a subsequent event which happened after. Unfortunately, from a direct policy, we can't deviate from that. Want the money, we'll have to sign the discharge.
But if I,
Otherwise, you can't. It's not.
but if I sign the discharge, that would be
Exactly. Otherwise, you can't do it. If you dispute it, it's not within the writ petition at all. It's not within the scope of the writ petition.
How this court can enter into that?
my lord, if your lordships permit me to withdraw that.
Yeah, because otherwise,
Before your lordships, my lord,
yes, now and here, we can do it. Otherwise,
If you want 5 crore, then Mr. Banerjee is ready to give 5 crore.
Yes.
no, but that would be akin to my lord waiving of my claims, my lord, which is over 50 crore, more than 50
That's
crore.
why. So you
But
so how this writ court can
No,
adjudicate?
but-
They already adjudicated a 5 crore.
But my grievance is from an event which is prior to that, that they have rejected my extension of time. I have a policy which allows me to reinstate the entire property, and that price I have to obtain from the insurance company. Now, my lord, the insurance company sits on my request for extension of time. Much beyond that period when the reinstatement is completed, then they reject without reasoning.
I totally agree. This court now, because now new cause of action. If new cause of action, then you have to, either you have to accept that the calculation made by them, the finding which they have arrived at, or you have to challenge that. If you want to challenge that, how you can challenge in the writ
My lord, I understand that, my lord. However,
and take all the precautions
Malad,
before the
if I am permitted to receive that money without prejudice, Malad, because I already challenged all the Malad, grounds that I have. Now, Malad, in
if
this.
suppose I will give liberty also,
Yes.
what will be decided in the writ petition?
It cannot be done.
Malad, I'll indicate, Malad. Malad, the assessment of my claim has been made on an indemnity basis.
Correct.
When Malad, the policy was purchased for reinstatement value basis.
Correct.
Now, Malad, I approached your lordships at a time when my request for extension of time for reinstatement was rejected without any reasons. No, that I can show
Because
that.
you have not gone within time. You have not approached that.
No, Malad, I have.
You have asked for the time.
No, Malad, my request, and the provision is there. The provision is there that within the period of reinstatement, I can approach the insurance company for extension of the reinstatement
Correct.
period. I have applied within the period. Within 12 months, I have applied for reinstatement, extension of reinstatement. The company does not respond to my request. The assessor also is in communication with me. Beyond the 12-month period.
Clear in the writ petition.
Kindly has the writ petition, my lord. My lord,
Commanding Rashma for the satisfaction and withdraw its rejection.
page 34.
Yes.
All
Con-
matters become no.
Withdraw its rejection for extension of time.
Correct.
But I had
That rejection is now
Yes.
coupled with the final order now.
Yes, now we have a final survey report.
Final survey report.
Survey report has been prepared on indemnity value basis. The reason being, the reasoning is given. The reasoning given is that there is no extension of time for reinstatement. So, my lord, that if your lordships find that the rejection of my reinstatement request or extension request was bad, then, my lord, we can go back to that stage where the assessment has been done. Assessment by the valuer has been done with all the calculations. The only caveat being that because it is not on reinstatement value, I have to deduct. So, my lord, if your lordships simply hold that the rejection of request for extension was bad, then there is no difficulty.
Commission will decide it. How is that? And the final report will be set aside then. What my learned friend is saying.
Yes, my lord, then my lord, the assessment will be done as basis the reinstatement value. But there will be no difficulty, my lord, in my humble submission.
You're asking
No.
for setting aside of the report when you have not challenged it.
It's a subsequent.
Now the report has come.
In my IA, I have challenged the report.
How it can be?
But because it's subsequent event, in my IA, I have said that this assessment itself is bad because it is done on an indemnity.
What you have prayed for in the IA?
Kindly has page 14.
Well, we don't have a.
No, I have served, my lord, I have an affidavit of service.
Yeah, at least I haven't.
Page 14.
Petitioner to request extension of reinstatement period communicated by email dated 2017 is arbitrary, reasonable. The same, what you have prayed for in the writ application.
My lord, I am led by Mr. Shoma Majumdar, kindly permits me.
Yes, Mr. Majumdar, how?
During the pendency of the
Yes.
proceeding, they have finalized the claim.
Correct.
It appears that there is some dispute as regards not the settlement of the claim. I have claimed 41,000 on reimbursement basis.
41 crores.
Oh, sorry.
41,000 we are willing to pay. We have assessed 5 crores.
No, I can't think beyond that.
So,
It's my incapacity.
my lord, I'm accepting the demand on behalf of the insurance company. My lord, I'm sure they won't.
No, that is bill of Mr. Majumdar.
Well, I'm raising a preliminary point, Mother. The petition is no longer maintained. Now that Mr. Majumdar, it's not maintainable. It's a question of Mother. Anyway, Mother, it will question of disputed facts.
Yes, Majumdar, after this survey report, how this writ petition can continue?
No, the question is not who was at fault.
No, that's correct.
The
But
policy says, yes, I was only praying for this. The application is only for this. They have issued an order. They want this to be accepted in full and final settlement. But I have a dispute as regards that. And what is reimbursement is not replacement of the properties. But let me accept this without prejudice to my rights and contention so that I can get it through a process of arbitration settled.
So that can't be, Mother. We can't, Mother, do that.
There's an arbitration clause in the proceeding as
We
well.
make payment if you agree. There's a settlement box.
go to the arbitration, challenge it, and you make a prayer before the arbitrator, then you can obtain the order from the arbitrator.
They have indicated an amount of
Correct.
5.76 crores.
So you withdraw this and go for the arbitration. In the arbitration, you file an application, arbitrator pass an order subject to the outcome of the arbitration proceeding, because this court cannot decide now.
No, I am not seeking for a decision.
This court cannot decide. So how this court can say?
I cannot pay, Mother.
Prejudice.
It's the final.
So if you wanted, you go with arbitration, you can take appropriate.
There is a subsequent development which prompts me to make this prayer. The subsequent prayer, the development is, they have said that the delay has occurred because of you. But there is a 12-month time period during which this reimbursement has to be done.
Yes.
No matter who was at fault, I can try to demonstrate from this.
But how this?
But not the question is of discretion to be exercised by a writ court.
Correct.
Your lordship's court may be permitted, but that's a question of discretion. But as a matter of right, I have a right to lead evidence before the arbitrator.
Correct.
So that if this amount is fall short of my claim, if this amount could be fastened to me, if I could receive this.
An interim award, Mother, here.
Not an interim order or an interim award.
Huh? Application 153.
My lord. Please submit the policy first, not at page 46.
But it is better. You go.
No,
I don't.
I am not shirking off not an arbitration proceeding.
Then
All that I was saying is because of the.
This court cannot invoke the jurisdiction
No,
of
no, I'm not.
9 or 8.
No, because of the devastating fire, I had to shift this installation from UP to Gujarat. No, this had to be pulled down, dismantled, and not whatever was remnant, no, this has to be accommodated in Gujarat. Please have a look at 46, no, what is this for? The company, the second line on that page, 46.
Page 46.
My lord, of the writ petition.
Yes.
In consideration of the insured name schedule, company so and so, the full premium mentioned in the said schedule, the company agrees, not I skip over the bracketed portion, that if after payment of the premium, the property insured described in the said schedule or any part of such property be destroyed or damaged by any of the perils specified hereunder during the period of insurance named in the said schedule, or of any subsequent period in respect of which the insured shall have paid, and the company shall have accepted the premium required for the renewal of the policy, the company shall pay to the insured the value of the property at the time of the happening of its destruction, or the amount of such damage, or at its option reinstate or replace such property or any part thereof. But the chain of events show that they intended to replace this property. Not replacement is the duty of the company, whereas not restoration not is my duty. But the parties proceeded on the basis of this replacement. There is a period of 12 months during which this replacement has to be done.
Yes.
The survey report was wanting from the end of the insurance company for the purpose of completing it within the time frame. Now, not whose fault it is, but probably your lordship may go into it, your lordship may not be inclined to go into it.
Yes.
Which may fall for the arbitral tribunal to decide. But not what remains settled at this stage is 5.69 crores. In any event, they have settled it as a non-reimbursement policy.
Okay.
My claim is further in excess of what is being settled there.
An adjudication on the settlement amount itself. Because this is not a full and final settlement which one of the insurance company has to pay. Maybe right or wrong. But either he has to challenge it, or I don't know whether the writ for
that I'm asking.
That's right. But he has to challenge it with others. We can't pay it without there being a final. That's the report which will go.
Adjudication at this stage. Final order under adjudication is at 333 or one liner.
Become infractions.
333?
333 in the third volume of the writ.
Yes.
We would like to inform you that the company authority has declined the extension request made. That's all.
Yes. No, the insurance company is only taking the amounts consideration.
Yes.
That's right. That's how they have. That's how. That's what I'm saying. Right? Wrong. I don't know. That's what they have. I said, whether in this writ petition, that can be adjudicated or not. That's really the question.
Yes.
Now, on the face of these records, but I would submit that this on the face of it, this is an unreasonable order.
That's correct.
Which your lordship's court probably would have interfered with.
No, then if you wanted, then I will decide.
Not only for
they have to file the affidavit.
Not only for the sake of not convenience of, not convenience, not for the survival of my client. But as against 41 crores, it's 5.69 crores. Now, on this assurance, we had set up a new factory, or whatever it is there. But not as of today, if the parties are permitted to go for arbitration, not this amount be released without prejudice to my rights.
That's why, that's what I'm telling. If you wanted to go to the arbitration, you go to the arbitrator and file an application before the arbitrator for release of the without prejudice. If it is permissible, the arbitrator will pass an order. Why this? If this court is not going to enter into the merit, why the court can pass an
this order probably in insurance contract, which has a public element in it, but this order can be interfered with.
That's what I'm telling. I can interfere. Then I have to give the opportunity.
That does not solve the problem.
Let they file the affidavit. I will decide. No problem. If on the face of it is unreasoned, then there is no problem. Let they file the affidavit.
Required or not, whether the petition survives or not,
then
all that will come up.
Then the writ petition is to be decided on merit.
Can you do that? Kindly note that, trying to note, that's my instruction.
Well, I'm just raising a question of interim.
To question this,
To contesting.
Very good. But if my learned friend could.
I'm not raising a question of integrity and because I don't think the threshold is become infractuous now. Because by way of us, another interrogatory application.
Learned counsel appearing for the respondent's insurance company raised the preliminary objection with regard to the mentality of the present date application, and further submit that after finding of the survey report, the writ petition had become infectious. Learned counsel for the petition submitted the writ petition is to be decided on merit, as the impugn order is unreasoned order, and as such this court has to decide whether the order passed by the authority insurance company is sustainable in law under law or not. In view of the above, by keeping the point of maintainability open, the respondents are directed to file affidavit in opposition by 3 weeks. 3 weeks reply, if any, they are to be filed within 2 weeks.
4 weeks.
2 weeks, 2 weeks. 4 weeks, 2 weeks. 4 weeks, 2 weeks. List the matter. कब होगा? 4 weeks, 6 weeks हो जाएगा? हाँ, 28 September at 3 p.m.
Grateful to Lordship.
I'm going to serve as a copy of the application.
The petition is directed to serve the copy of the application being GA number 1 of 2026 to the petitioner, and the petition liberty to deal with the said application by way of an affidavit on the above mentioned time.
And may I file the affidavit of service?
Open link then affidavit service, file the petition, kept with the record. Yes.
Dear Lordship.
चलता क्या? Yes. The train is late. Train is late. Late. If you are having the reservation, then you have to wait.
Yes. That's what I was going to say. The train is late. Your ticket has not been cancelled. Well, and I will not hold your lordship much with this matter, because before troubling your lordship in the papers, Millard, let me give a background. Millard, the petitioner before your lordship, Millard, is a manufacturer of iron and steel.
Manufacturer of
iron and steel. One of the industries in West Bengal. It employs about 1,200 workers and all. Now, Millard, it was a running concern. There was no difficulty in that. Millard, times became hard when Millard COVID set in. Millard, as your lordship knows, Millard, COVID brought in a lot of issues. And so far as these industries are concerned, Millard, their production stopped, operations stopped, but we had to pay off the workers and all because they were the directions and they were the circulars which was operating and governing this. Now, Millard, we were operating this industry. We were operating this industry with the help of 3 financial institutions. State Bank of India, Punjab National Bank, and Indian Bank. These are the 3 financial institutions which we had commercial relations. Well, by commercial relations, I mean term loan, cash credit, running facility. Well, your lordship knows, well, these companies, they have this. Now, it so happened that owing to this COVID coming in, Millard, there were certain defaults that had occurred in respect of these financial institutions, which was obvious. And to obviate these difficulties, Millard, the government had also issued circulars from time to time, extending time for defaulting or extending the time for the purpose of giving protection to the person. Now, State Bank of India, who was, Millard, the biggest, had the biggest stake in the company, they, Millard, had a claim of 500 crores or something like that. 500? No. 250? No. For original claim? 500. 500 crores. That's what I said. Now, they gave us a notice saying that we are going to transfer a portion of your debt to a ourselves. which is Milord, a company under the SARFAESI Act. They came up with a notice, gave us a 13-2. We contested the 13-2 because thereafter they did, from 13-2 they did not go to 13-4. They did not pursue that 13-2 notice in under the SARFAESI Act, but they went the other way of transferring the assets, Milord, to an RCEL. The loan exposure, Milord. So, Milord, and the difficulty that arose that once RCEL takes over, Milord, the loan exposure, Milord, not being in a position to do banking business, Milord, my finance gets stuck. So I was not in a position to run whatever I was left with. So, Milord, at that juncture, on the ground of there are certain irregularities in the sale process, we came before this Honorable Court. That was the first writ that was filed. When we came before this Honorable Court, Milord, we got an ad interim stay straight away on the ground that the rules read with the COVID circulars did not permit the declaration of NPA within the time the circulars had said. They had not calculated the days which the circular gave me an exclusion. And therefore, I was not an NPA. Hence, if I am not an NPA, you cannot take further steps. This was the ad interim order passed. This order also, Milord, after affidavits were exchanged, achieved finality. Now, against this final order, Milord, this entire process of trying to sell up my assets, this, that, got set aside and things got restored. Till such time, the other two banks, Milord, were also pushing us, but they were not taking any steps. Now, thereafter, it so happened, Milord, against that, Milord, an appeal was carried. The Court of Appeal held that, look, maybe there has been a miscalculation in the calculation of the days then. But for non-payment after that date, which should be taken into consideration, you have become an NPA. And therefore, the trial court order was set aside. This is not correct. Either you pay or we are going to send you, your assets would be sold or whatever was the impugned. When this appeal was going on, Punjab National Bank came into the picture. Punjab National Bank had an outstanding around 67, 68 crores, but he also started doing the same thing and we also got an interim stay in that. Now, once this appeal got disposed of, we had to go to the Apex Court. The Apex Court on the very first day said what the court has said, that you pay. You have to pay, but suggest the way in which you will pay off. But the difficulty that arose is in the meantime, the asset already got, that loan exposure already got transferred because there was no stay. The Supreme Court, Milord, gave us the protection that since it has already been transferred at 250 crores, that's the minimum amount that you should offer. And so we had a benchmark, the 250 crores. And there was in the meantime stay of all coercive proceedings and everything was stayed. Now that proposal of ours, 250 crores, was discussed with the bank authorities and the lawyers, and it was accepted. And that stay till date continues. And we have
that 250 is only with regard to SBI.
Yes, only with regard to SBI. And that continues, and thereafter, Milord, probably 19th is the day when it will achieve finality. An entire payment would be made because a committee has to be constituted to calculate the interest component that was due on that reduced amount. Now, in the meantime, Milord, Punjab National Bank also tasted blood because, Milord, payment has come. So, Milord, he also, Milord, followed the same queue. Ultimately, the matter through this went up to the Apex Court. This time, little easier was the route because everything was decided. And it also, Milord, went and got stayed. On the ground that pay something. Here, Milord, some upfront payment was agreed upon, and thereafter, Milord, that proceedings have also been stayed. Now, Milord, so far as the third bank is concerned, now, Milord, it is their turn. Now, Milord, in this interim, in this writ petition, Milord, there is an interim order. The interim order which is passed in Milord is in identical lines with the interim order which got allowed, appealed, and is consideration before the. So, Milord, whenever your Lordship will see us, Milord, coming, we always come with a prayer that whatever you are deciding whatever we will be arguing as an ad interim prayer, Millard, would, or whatever be the final arguments that we make, would be the same argument which is in the State Bank matter, which is if any of these courts hold that there is no question or the calculation is wrong, then obviously all will follow suit. But since there is a settlement, probably in those two matters, it may not be relevant. Having said that, Millard, so far as the interim order which I will have to place in its entirety almost takes care of everything. Entire arguments that we have made, and that entire arguments which we have made, we will have to compare with the entire argument which is made by State Bank of India in that matter also. So your Lordship is Millard, I am at your Lordship's disposal. Either Millard, your Lordship can wait till 19th, so that Millard, if ultimately it is set aside, Millard, then obviously I cannot and I am not taking a submission with your Lordship that I can run away with the dues of a bank. It's neither here nor there to say that. It's a question of, as Mr. Corbat also, it's a question of what would be the upfront figure. My lords have, Millard, from time to time indicated and directed us that you give them a proposal. Follow the line which you are following with, because they are a financial institution. They are only interested in their money.
What is the amount involved here?
Millard, here the amount is around 50.
The web notice was 32 talks about 98 crores. No, the talks 91.
91 crores.
And the web notice.
And the web notice is 67. 67.
So we are proposing 60.
And we have offered them 60.
No. The web notice is 56. We have offered them 57.
57. We have offered them 57.
Here also you are offered.
Yes, sir. We have also come up with an offer with them. The only difference in the offer is this, Millard, that is in line. Because none of these courts, Millard, in the apex court also, Millard, none of them say pay it. They say deposit it with the registrar. That is where the difference has come up. My learned friends' clients, obviously, Millard, we have given them offers which are in writing. So I cannot back out by saying that I don't have any liability. What they say is that you make upfront payment, which are all to me. And we are saying that if you are trying to follow the lines of the judgments of the apex court, Millard, then those judgments say that you deposit the money in court. Money is yours. That is where the difference lies. So even on the last occasion, Millard, we had given them an offer. We had revised our offer. The courts have, there are at least 4 or 5 orders in this matter, Millard. We were asked to revise our offers. We have revised it. But Millard, the only point of difference is, Millard, you pay payment to me, and we are saying we will make payment, but in terms of the judgments which are, or orders which have been passed by the apex court, we'll deposit it in court pending the outcome of the rate. Or if those are settled, Millard, then you also follow suit. But we have to reach at a figure. We have to reach at a figure. Now, thing is this, Millard, this second argument of mine, reaching at a figure, Millard, I can ask your Lordship, Millard, to interfere, but I don't have, Millard, the right to say that legally your Lordship has the right to compel this. Because my learned friend will obviously have to agree to what falls from the court. So, Millard, if this is, Millard, the situation.
So why all matter not gone sent to the mediation?
My reference to stress is petition. Because Lord, it's a stress asset sale, which has been held up, Lord, since 23. At that stage, Lord, we did not have the benefit of the 2 division benches order, which was passed in their matter. Bench has not interpreted that, your Lordship that, and my learned friend says deposits. But they have to take the entire money to State Bank, maybe some around outstanding. So far as State Bank is concerned, there is no question of deposit. And so far as the Bajaj Bank is concerned, the court had directed you to deposit 5 crores and then give your order. So they paid to deposit that money. Last order I find.
No,
something, and the balance 3 crores they were given time to deposit. I don't know whether they have deposited.
Well, your Lordship can take it from me, 5.25 crores. The order
let me place the petition. It's a very short point. Your Lordship, kindly hear out the petition. It has got nothing to do with the other 2 matters. Lord, they chose to file the other petition, which has gone to the Supreme Court. So as this matter is concerned, kindly deal with it.
Yes.
পেড করেছি সেটা কোথায়?
They are not concerned with whether they have deposited, not deposited, whether they have paid. Lord, as far as the Indian Bank is concerned, they have not approved them. Account was prepared NPA 27th of December 2020, not a penny has been missed. So Lord, we really can't.
Yes. Now, Millard, the reason why I had given this, Millard, introduction is this, Millard. My landed friend wants me to move the writ petition. I have no problems with that because it's my writ. Now, Millard, the point which I am arguing, my landed friend says that he is covered by the division bench judgment, which is being stayed by the Supreme Court. So, Millard,
Still pending.
Yes, Millard.
Supreme Court?
Yes, yes. As I told you, Lord Shimilan, 17th is the date for Punjab National Bank and 19th is the date for State Bank.
Supreme Court.
Before the Supreme Court. Now, I would be arguing the same thing that I was there in that entry. My learned friend would be arguing what the appeal court has held, but ultimately it will go down to that stay. So, Millard, it would be, Millard, if I, with respect, Millard, I think my learned friend is trying to give an impression to the court that I am running away.
I have not. Lord, I just want to say he has challenged the declaration of NPA and Lord, the state assets, the advertisement by which the assets were being transferred.
Already transferred?
No, it has
No.
not. Because they
Stay order.
report and they.
But it stayed.
Yes.
And that stay is still operating. That's what I want. I
know what you want.
Millard, what I want is this, Millard. If Millard, because to argue this writ petition, Millard, Lordship will have to give me some time to get ready. I am ready so far as the facts are concerned. I will have to place the two orders, and Millard, that will take some time. What I want is this, Millard. If I'm not in a position to Millard complete it today or give a date where I can come and complete. In the meantime, I've given them an offer. I've given them an offer. But they have to indicate the reasons. I am offering.
The reason is that you don't. There is a proposal. There is a.
No reason to know.
There is a bank that if you are giving a proposal, you have to deposit a certain amount as 10% or whatever towards the consideration of the proposal. We are not prepared to consider the proposal unless that money is.
Now, Millard, this norm,
without deposit of money, this proposal means nothing.
So, Millard, this was what is norm for a nationalized bank official Mr. Kaur is representing. Millard, is also the norm in respect of State Bank of India. Now, there, Millard, the same contention was made when we went before the apex court, Millard, and that is the order.
Payment.
I'm saying that. I am saying that.
What has happened in the apex court? Let's have the benefit of the petition being heard. Lord, kindly, Lord, hear out
Supreme Court order.
From 2022 to 6 years, Lord, they have got a complete holiday. Not a single naya paisa has been paid in their accounts. From the date, Lord, the NPA was. They are paid.
No, state.
So whatever the bank.
Deposit in court যেটা লেখা ছিল. Millard, as I said, Millard, whatever is the Millard norm for Mr. Kaur's client who is a nationalized bank, the same norm applies to State Bank. Now, Millard, the same prayer was made before the State Bank, and this is the observation. If Millard, the of course, তুমি তো বলবে আছে আমার সেটটা দেন.
So you paid this amount?
Yes. That is, Millard, after payment of this entire amount.
2.25.
Yes. 250 crores.
Achha, 50, yes.
250 crores. Now, Millard, the dispute is, Millard, the quantum. So, Millard, a committee was formed and the committee has gave its report. Both parties, the retired Justice Dave Millard was engaged to give a report. There have been exceptions, cross exceptions, and ultimately, Millard, 17th or 19th is the day. So, Millard, if that is accepted, Millard, it is the lead bank in the consortium.
So, whether in the Supreme Court pleadings completed, it will be ready for hearing.
Millard, it was taken up in at least, Millard, on at least, Millard, 5 to 7 occasions.
Yes.
Now, my lord, nothing will, in my respectful submission, my lord, if this main bank, which is, my lord, the consortium main bank, my lord, if that bank, my lord, views are satisfied, my lord, and, my lord, it gets rectified, then another question that will come, that being in a consortium, how far you can, my lord, because the assets will be charged to the main bank, how far you can proceed with your notices any further. That's the reason, my lord, why we are saying that
this interim order is still disposal.
Well, let's so far continue. Yes, in both the matters.
So when you will argue?
Millet, give me a date. I also have a leader, Millet, who always opposes me, Mr. Bachawat. But now I have an opportunity to. I told him, Millet, this is something very light, Millet. He said, it's your baby. You handle it. I said, from baby, it has grown up to a full child. Now at least you come before the court. He said, do it. He said, he'll do it on another day.
So your Supreme Court matter is pending on 19th.
17th is PNB. 17th is the PNB matter, and 19th is
the State Bank is concerned. What you have seen,
yes,
it's a payment made to the State Bank.
Correct. That's
no question of any
yes, that is the
issue is
deposit in court ta dekhao na.
This is not in deposit in court.
No, sorry, it's the PNB which is
250 crores paid to the bank, and PNB which says that they
no. With respect, my lord, this is not to the bank. This is, my lord, to the person whom the property had already been assigned.
ARC.
Just
obvious, because the property had been sold. Instead of bank has assigned the.
Yes, so
they have received the money. Therefore, the ARC has received the money. This is payment, actual payment paid to the ARC.
Yes, after 250 has been decided by the court. No, this is not after.
250.
But kindly hear out the matter instead of this piecemeal hearing, Supreme Court hearing.
That's why I'm fixing a date so that matter can.
Give it some time after 19 because the scenario might change.
There will be no change in the scenario so far as Indian Bank is concerned because they don't want to pay. So, we remain.
But I have given them offer.
Total is 98. You have given the offer of how much amount?
Total 67.
60.
67.
67.
56.7.
What is the principal?
Principal will have to check because they wanted to assign it for.
What was the principal?
The web notice says that they want to assign it for 56.74 crores.
SBI 250.
At that juncture, Millard, if I had offered them 56.67 crores, Millard, then they could not have done it. So we take that 56.67 crores is actually what they are selling the asset at.
They had offered the money.
And that is the same basis.
We are 6 years down the line. So, Millard, there is no question of Millard, what happened then.
And that is the same thing happened, Millard. Once the asset got transferred, the third party interest, we had to.
91 lakhs,
okay.
26,000.
91
crores, 26 lakhs.
How much time will take?
Millard, keep the date after 19th.
Learned counsel for the petitioner has argued the matter is not, but due to paucity of time, hearing could not be completed. Let the matter appear on 16th, 17th, and 21st. 21st September 2026 at 3 p.m. for as a specially fixed matter.
Also, that your ticket is not been cancelled.
No. I am fortunate enough, so that I have got the chance. Well, this is a very short matter. Well, I have submitted my written notes of argument. Well, I am not going into that. Kindly come to my lord. Straightway, my lord, take the written notes of argument in both the matters. The issues are same. My lord.
What matters?
Subra Roy.
Yes. Yes.
My lord, here, my lord, kindly come to straightway before the facts. My lord, facts are very much, my lord, actually very short facts. So before starting before placing the facts, my lord, straightway kindly come to the legal point which has been involved in that. My lord, 425A.
My lord, kindly see, my lord, may I?
MC আছে কি? না। না।
My lord, can I take it up? Take it up,
Yes.
my lord. Because I have read, my lord, subject to my lord's approval, my lord, kindly see. My lord, I have taken note of in my written notes of argument also, my lord, everything is exhausted, my lord. If, my lord, the
What is the
judgment.
prayer?
My prayer, my lord, so the prayer is to delete the purported inclusion of my premises as a heritage grade pending list. And my lord, the issues where these issues, similar issues were being raised at the previous occasion in another case. And my lord, up to division bench, it was upheld that you cannot do, because if there is a law, you have to follow the law.
Correct.
And my lord, you cannot pick and choose, my lord, whatever you feel that it is appropriate for you to come to a decision. My lord, here, my lord, the premises in question, admittedly, my lord, there is total violation of the amended portion. My lord, kindly see 425B for 425. My lord, it starts with, my lord.
You give the section, what section you are referring, I will take. Note, you read it.
It starts with, my lord, 425A, 425B, 425C, 425D, and these are the relevant provisions, my lord, and 425O. These are the relevant provisions on which, my lord, I will make my submission in a shortest possible way, my lord.
Yes.
Because, my lord, kindly consider 425, because admittedly, so far the issues are being involved in both those cases, my lord, same issues were being involved in another cases. And, my lord, there they have the trial court, the coordinate bench, the honorable coordinate bench passed an order deleting the grade pending list from the petitioner's premises. And being agreed with that, my lord, KMC preferred an appeal before the honorable division bench. Division bench, my lord, kindly straightway come, my lord, my written notes of argument, my lord, that is page just a minute, my lord. Page, my lord, 102 of my lord, written notes of argument of the honorable division bench order. My lord, kindly come to page 102. My lord, got it?
Yes.
My lord, kindly see next paragraph accordingly. My lord, got it?
Yes.
Accordingly, the observation of the honorable single judge under discussion in this appeal to the effect that the acceptance and adoption of the entire list en masse does not amount to compliance of the provision of section 425B of the KMC Act.
Yes.
In the judgment and order impugned dated 30th August 2019 shall be read as applicable to the facts of the said building alone in the issue of the petition, and this appeal accordingly clarified. So, my lord, whatever judgment was, my lord, delivered by the honorable coordinate bench, that was upheld by the honorable division bench, though there is a challenge of that order, impugned order, before the appellate forum. So, my lord, kindly consider here the same points are being raised. That, my lord, kindly see that you have incorporated my premises as a heritage grade pending list.
By notice not issued?
No.
Publication was not.
No. Only in, my lord, no hearing was given, and not only that, 425C, my lord, this new law has come into effect on from 22nd December 1997. Malad, it is written, Malad, in the first, Malad, kindly take a note of it, then, Malad, last portion, Malad, last portion.
Yes.
This amendment, Malad, 22nd, Malad, can you see?
22nd December 97.
Yes. So, my lord, admittedly, so far facts are being concerned here and in earlier cases, my lord, I should say there cannot be any comparison.
Yes.
Similar facts. My lord, that their contention was in the appellate court as well as in the single bench that no rule is yet to be framed in terms of section 425D, because unless it is to be categorized, for which rule has to be framed. And the recent division bench says, in another cases, that the KMC is yet to make a final rule. So there cannot be any gradation unless rule will be framed as per this act. And what is their contention, my lord? Their contention is very much, my lord, restricted to the same that my lord, kindly come to my my written notes of argument, my lord. Kindly come to first, my lord, kindly come to page 5. Page 5, these are the issues, my lord, so far these writ petitions are concerned, and same issues were being raised in earlier writ petition, as well as in other writ petition, though I am not a party. Kindly see, following issues have been emerged as the first and several instant writ petition. First issue, kindly see, as to whether there is any decision-making process at the behest of the respondent Kolkata Mission to treat the property of the writ petitioner as described under the heritage grade pending list, grade 3. As to whether the respondent Kolkata, by incorporating the property in question of the writ petition as described above under the heritage pending list, had complied with the provision of section 425B and 425C. Well, I had already got it.
Yes.
420C of the Calcutta Kolkata Municipal Corporation Act 1980. C. As to whether the Heritage Conservation Committee of the respondent Kolkata Municipal Corporation in its meeting dated 17/4/2000 recommended 828 numbers. Well, same things. They have narrated in earlier the matters in the appeal court. Same thing, my lord, they have incorporated in my
this 828
including concern
in your name also.
No, well, kindly consider. Premises of the writ petitioner here as described in the city of as identified by the here this is important. As identified by the expert committee of the government to be listed as heritage building under the provision of photo. Kindly see 17/4/2000.
Yes.
But on the basis of, kindly see expert committee.
No, that's why as to whether, so that 822 numbers of building in which your name is also there.
No.
So, what
no.
As to whether the heritage conversation
in his meeting recommended 828 numbers of building including the concerned premises. That is the premises of the writ petitioner described in the city identified by the expert committee. That is my saying. Identified by the expert committee of the government to be listed as under the provision of 420 of the Kolkata Municipal Corporation is to be treated as perverse or not. Because expert committee, in terms of the recent the present amended, that is December, before that expert committee was formed, and whatever recommendation was being made by the expert committee, they have just got the approved, or they have just approved the same. Because my submission would be, first of all, my lord, then my lord, I am making my submission as to whether after coming into force, this is important. Chapter 23A of the Kolkata Municipal Council with effect from December 22, 1997, with regard to preservation, conservation, and heritage, respond Kolkata Municipal can at all adopt, well, this is very important, adopt the findings of the expert committee, which was constituted on 6th October 1997, relating to gradation of heritage pending list in the city of Kolkata, which includes the premises of the British. But this is, there is my kind question. This is my lord, the question, the very, very relevant. This is has to be, my lord, their answer is their answer to this, my lord, the whatever submission they have made before the on the honorable division earlier in earlier cases, same as the submissions or same affidavits they have used in their affidavit of opposition.
Okay.
Because, my lord, kindly see, and my lord, as to whether when admittedly.
So what is the judgment passed by the court?
That delete the gradation, the premises from the heritage get pending list, and the honorable division bench upheld that. And my lord, kindly see as to whether then next question, this is important, as to whether when admittedly there is no rules being framed by the responsible corporation with regard to gradation heritage as per section 425C of the Kolkata Municipal, the purported inclusion of building in question it was described in the heritage gate 3 is that all valid or legal in the eye or not. But now kindly consider as to whether the respondent is duty bound to follow the provision of chapter such and such containing 425A to 428P as amended with effect from December 2019, incorporating the premises in question that it has described in the heritage pending list. Instead, kindly see, this is my and the honorable the single bench, my lord, the coordinate bench has upheld. Yes, the submissions being made by I was there, my lord, in that. But instead of adopting the recommendation of the expert committee constituted on 6th October 19 regarding tagging of heritage building premises situated within the vicinity of Kolkata, where there exists a law in that regard. But already, kindly see, this is their own facts. Whatever I am making, whatever submission I am making, I am only referring.
Now what they are telling in this, in your case?
Because
their stand.
Their stand is same. Same. Because kindly see, kindly come to page 7. Page 7, my lord.
Yes.
With regard to issue number A, it is respectfully submitted that the affidavit in opposition, kindly see. Sorry. Affidavit in opposition being filed by the respondent Kolkata, there was no disclosure of decision-making process with regard to inclusion of premises in question of the writ petitioner under the heritage grade 3. On the other hand, in paragraph 9 of the affidavit in opposition filed by the respondent Kolkata disclosed that only the corporation, that is the restaurant corporation, in its meeting fancy 25th February 2009 approved the recommendation of MIC regarding list of, kindly see, heritage building and their gradation under grade 1, grade 2A and grade 3, grade 2B. And there is no mentioning of approval of the recommendation.
How this court can have a determination?
Yes, madam, because irrespective of classification of cases.
No,
well, I check it. Well, otherwise I will not come. I check it. Well, kindly see, this is very interesting point of law, my lord. Kindly consider, because I have, so for my written I have exhausted, my lord, I have, whatever in terms of law, my lord, I have explained, subject to my lord's approval, whether my lord will take it or not. Kindly see, there is no provision mentioning of approval, recommended provision in the question as described, and it is going to pending 3. There are various stages, my lord, my submission would be very much limited, my lord. Why? If there is no rule, straightway kindly come to, there is no rule as has been admitted by the, or approved by the honorable division bench of our High Court. Kindly come to.
Still the rule is not framed.
No, kindly come to page 131.
Of the?
Of the 131 of my lord, the written notes about.
Yes.
Kindly paragraph 14.
Yes.
It is already, my lord, 18, page number 18 up to.
আরে এখানে সব আপনার লেখা আছে এখানে
কি লেখা আছে? You have.
না 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 ম্যাডাম কাইন্ডলি না 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 without this ম্যাডাম কাইন্ডলি ম্যাডাম কাইন্ডলি no kindly this is there
It cannot be.
ম্যাডাম kindly consider
They have given 18 pages only, and he is relying on 113, 114.
ম্যাডাম he has totally he has to kindly come to টাকাটা জানে না ম্যাডাম kindly come to page 18
You have to give.
page 18 kindly come to page 18 ম্যাডাম kindly come to page 18 page 18 I have stated everything in their affidavit and in my writ petition and that page pagination is
They are
there
placing the writ petition and the affidavit of his only his argument, but then we have to
frivolous submission I should say my lord frivolous my lord kindly say frivolous submissions they are making my lord only thing my lord why they are so apprehensive my lord kindly see my lord
They will not angry because you wanted their building to be in your favor because it is a heritage building. How they can do that?
Sorry. Well, everything is written in black and white in paragraph 18 in their affidavit of opposition and writ petition.
No, whether this reported judge all are reported.
Yes, all are reported. This is there, my lord.
No.
My lord, they have referred. But I will show they have referred in earlier cases, in these cases.
Okay.
I will show.
Okay,
My lord, page 131.
Yes.
My lord, I am not a person, my lord, my lord knows me. 131, page 14, paragraph 14. Needless to say, this is another judgment or order passed by the Honorable Division Bench of our High Court. Well, kindly see, needless to say, Heritage Conservancy will decide an application for inclusion, delisting or downgrading or upgrading of any heritage building after affording resolute, এটা justice, honorable justice division
Bashak.
আরে আপনাদের এখানেই তো আপনারাই তো আন্দোলন করছেন but I am not
We will not follow the matters.
anyhow but they have relied upon in this case I will show then my lord they will understand what
That's correct, but you have to give the copy. If it is not a reported judgment, you have to give the
my lord they have relied upon in this case in earlier order it will be reflected.
Okay, but
Kindly consider, first, my lord, let me, my lord, needless to say, the Heritage Conservancy will decide an application for inclusion or delisting or downgrading or upgrading of any heritage building after affording reasonable hearing to the applicant. And the persons that are likely to be affected by such a decision prior to such committee taking a decision. Provisions of the, so my lord, kindly see this. Provision of this Act 1980 and particular chapter 23A empower the KMC to frame the rules regarding the procedure of Heritage Conservation Committee. And my lord, this defines the gradation. ইয়ে করিস না দেবাংশু বসাক সুভাষ রাশিদি কোনটা মানে তোরাই তো রেফার করেছিস এটা হচ্ছে ইনট্যাক্ট ইন্ডিয়া ন্যাশনাল ট্রাস্ট ফর আর্ট এন্ড কালচার হেরিটেজ ভার্সেস স্টেট অফ ওয়েস্ট বেঙ্গল আদার্স ফিল্ড থেকে এসছে প্রভিশনস অফ দিস Act 1980 particular chapter into empower the KMC to frame rules relating to procedure of heritage conservation. Court is informed that draft rules were prepared by the KMC was for of approval, that such approval is pending. So, my lord, why? If the rules are yet to be framed, then, my lord, earlier, whatever adaptation or something like even adaptation is illegal. Adaptation on the basis of the expert committee. On the basis of the expert committee, adaptation was being made. And, my lord, after that, my lord, that the amendment has come into effect, my lord, that December
97.
Yes, and there, whatever they are prior to that, and there is no, my lord, mentioning of formation of expert committee so far this amendment is concerned.
So now it has not been the proposed plan, the proposed rules has not been approved.
Yes. So, my lord, kindly consider kindly consider that unless gradation be made, how they can identify that your premises will be grade 3, grade 2, grade 1, grade 3? How? Why? What is their explanation? I just put that question to myself. Their explanation is very simple. Earlier, whatever submissions, whatever allegations or the statements they have made in the earlier cases, same has to be there. They are following the same.
Naturally, they cannot.
Expert committee was formed well before the amendment has come into, long before. And on the basis of the formation or the expert committee and their findings, they have just adopted.
So your name is only in the list, not approved.
No. So, my submission.
When the list was prepared.
Yes, madam.
When the list was prepared.
That is in the year 2000.
2000.
And madam, kindly
what is the procedure they have followed for preparing the list?
First of all, my lord, they have to follow yes procedure. My lord, kindly say, come to my lord.
What procedure they have followed? What the procedure in book, that is book. Whether
they followed.
How they have prepared the list?
On the basis of the result of the expert committee. Expert committee has found.
When the expert committee found.
That is in the year 19 is this that in that affidavit it is stated. Long before the
amendment.
Long before the amendment has come.
Yes. 22nd December 1997.
Yes, before that. And no, after that no.
Still the committee is continuing.
Yes.
The committee is there.
Yes, yes.
It is by post or by name. Committee.
Name, not by name.
By name. So how the by name the continue?
That is in the rules when it is there. How the what is the formation regarding committee, my lord? That is there. But my lord, my submission would be first of all, there cannot be any gradation unless rules be framed. The honorable division bench.
That's what I'm telling.
Yes.
So
and first and second submission I am making subject to my.
How the gradation was been made?
Yes, they are on the basis of the on the basis of the explanation given by the expert committee, their opinion, and the Heritage Conservation Committee, Alice Committee has adopted that. This is their standing before the honorable division bench and single bench, as well as in this present writ petition. In the affidavit, I will show that.
Okay.
My lord, kindly consider, my lord, I have got nothing to submit. I am closing my argument. My lord, taking part up and let them, my lord, give an answer. Because I will and supply, my lord, regarding this thing. I am handing over my copy today. So that, my lord, yes.
Yes.
Well, kindly, otherwise, the building is in such a condition where more than 2 years, more than 3 years, 24 years, more than 2 years. Well, because in spite of having a home, it is not habitable.
So
I am rented. Yes,
you reside in the heritage building.
I cannot because
your address will be identified.
Kindly see the photograph.
Protected building. You do one thing. I will pass an order.
Yes.
What are your requirement in the building? I will direct to made.
Do not put me in that legal parlor. Well, no.
I will direct. You first you go to the engineer and prepare the plan. What plan you required for the
I have followed.
Till the notification is not made, you will be reside in the heritage building, proposed heritage.
No, it is large chunk portion of large chunk portion of the property. It has collapsed. It is not habitable. My lord can fix any officer of this court at my cost, see whether it is habitable or not.
Which area?
That is Dinabandhu Lane, Kolkata 706, ward number 0227.
Okay.
This is their my submission is I am completing.
So you are totally rely upon the earlier judgments, and
Yes.
they are also relying on that.
Yes.
So now the court has to see what.
Yes.
Yes. What is the ground?
Well, only it will take a kindly fix. As at 3 p.m. my lord, so just my lord, because my lord, I have to get rid of it. My lord, whatever which way my lord will pass, my lord, I am not nothing.
After puja vacation.
My lord, kindly do not punish me, my lord. I have got the privilege, well, I have got the chance so that I can make my submission.
Counsel for the petitioner has filed written notes of argument, has argued the matter.
And completed my yes.
Has concluded his argument, full stop. And concluded his argument, full stop. And counsel for the respondent, press for time. Current case is adjourned. Let the matter appear on December.
No, my lord,
22nd September at 3 p.m. Come ready on that day.
Obliged, my lord.
Thank you.
May I get back the book, my lord? On the next date, my lord, I will hand over.
Yes.